The August 12th meeting of the Board of Zoning Appeals is now in session. Good evening and welcome to this meeting of the Arlington Board of Zoning Appeals, which is also known as the BZA. I am Inta Malice, Chair of the Board. The Board is made up of 5 citizens appointed by the Circuit Court. In addition to myself, we have Vice Chair Peter Owen and members Judy Freshman, Paul Melnick, and Portia Clark. Also present is the professional staff, including Stephen Rizzi, coordinator for the BZA, Cliff Hogan, assistant to the zoning administrator, Blake Bowen, assistant to the zoning administrator, Mark Hamela, zoning technician, Shaquay McNeil, zoning technician, and Pamela Banner, administrative specialists. For the safety of our board members, county staff, applicants, and the participating community members, we are in a virtual meeting today, and all participants are joining us remotely. We are legally authorized to hold this virtual meeting based on the governor's executive orders, legislation adopted by the Virginia General Assembly, and the Arlington County Board's Continuity of Operations Ordinance, adopted in March of 2020. We thank you for being here and extend a warm welcome. Before we call our first case, I will share with you some general information about the Board of Zoning Appeals. Then I will also share some ground rules on how we will conduct this virtual meeting. The staff reports for each case on tonight's agenda can be found on the BZA website. Staff has placed a link to the agenda in the chat section of the session. If you have not seen the report for your case, you may wish to review it before your item is called. The board's powers are prescribed in the Code of Virginia and are set out in further detail in the county's zoning ordinance adopted by the county board. The Board of Zoning Appeals does not have the power to rezone property or to amend the regulations set forth in the ordinance. That authority rests with the county board. This board does have the authority to do 3 things. 1, we can approve use permits that allow modifications of placement requirements for structures on 1- and 2-family lots where there is no option in the zoning ordinance to allow such modification. 2, we can grant variances from the specific requirements of the zoning ordinance. And 3, we can decide appeals of decisions of the zoning administrator. When approving use permits, the Board of Zoning Appeals may impose conditions that it deems necessary in the public interest, including limiting the duration of the use permit. In order to approve a use permit, the law requires that the board find that the proposal meets conditions and that the use permit will not adversely affect the health or safety of persons residing in the neighborhood, will not be detrimental to the public welfare or injurious to property or improvements in the neighborhood, and will not be in conflict with the purposes of the master plans and land use and zoning related policies of the county. To do this, the Board of Zoning Appeals shall consider whether modifications will promote compatibility of development with the surrounding neighborhood, because the structure's overall footprint, size, and placement are similar to the structures on the property surrounding the lot in question, and whether the modification will help preserve natural landforms, historical features, and/or significant trees and foliage. When granting variances, the burden of proof is on the applicant to prove by a preponderance of the evidence that the improvements meet the following criteria. The strict application of the ordinance would unreasonably restrict the utilization of the property, or that granting the variance would alleviate a hardship due to a physical condition relating to the property or the improvements thereon at the time of the effective date of the ordinance, or that granting of the variance would alleviate a hardship by granting a reasonable modification to a property or improvement thereon requested by or on behalf of a person with a disability, and the property for which the variance is being requested was acquired in good faith and any hardship was not created by the applicant. The variance granted will not be of substantial detriment to adjacent property and nearby properties in the proximity of the geographic area, that the condition or situation of the property concerned is not so general or recurring a nature as to make reasonably practical the adoption of amendment to the ordinance, that granting the variance will not result in a use that is not otherwise permitted on the property or change the zoning classification of the property, and that the relief or the remedy obtained through the variance is not available through a special exception process as provided for under the zoning and/or subdivision ordinance. That concludes my general remarks. Want to tell you a little bit about how we will proceed with our cases. The order of the meeting is as follows. First, the cases will be called and a brief staff report and recommendation will be given. Following that, board members will ask any questions of staff that they may have. Next, applicants or their representatives will be given an opportunity to make comments to support the application or appeal. Next, all speakers for the item will be called. After we hear from the speakers for and against the proposal, the board may permit the applicant a brief opportunity to clarify any points. The board may also ask questions of any speaker, but does not permit and will not condone any cross-examination or direct questioning by others. We have deemed the following time limits for applicants and speakers to be sufficient: 20 minutes for applicants of appeal, 5 minutes for applicants of use permits and variances, 3 minutes for speakers representing organizations, and 2 minutes for those speaking as individuals. After the board has gathered all of the information they need and has discussed the case, it will decide the matter by voting on a motion duly made and seconded. A majority is needed to approve any motion. Any appeal from the decision of this board must be made to the circuit court in accordance with the state law. After your case of interest is heard, you are welcome to stay for the balance of the session or leave at your convenience. Finally, I would like to orient you to how we operate remotely with teleconferencing. Tonight's meeting is available to stream from the county's website via a Microsoft Teams link. There's also a dial-in phone option for those who wish to use it. If board members, presenters, or speakers lose internet connectivity during today's meetings, please reconnect with us by phone. Please keep your phones and devices muted until you are called upon. Turn off any sound to other devices around you to minimize interference. For guests joining us versus Teams, please turn off your video feed until your case is called. Only board members will leave their cameras on. When called to speak, please turn on your camera and unmute yourself by clicking on the microphone icon that is located on your meeting command bar. The moderator does not have the ability to unmute you. If you are dialing in by phone, press *6 to unmute. The meeting chat is active for presenters or board members who need technical assistance only. The meeting chat should not be used for discussion, public comment, questions about agenda items, or requests for more information. All public comments must be shared verbally for the record during the assigned public testimony period. Board members wishing to be recognized to speak will seek recognition verbally as usual. If we find that unworkable, we also have the option to use the raised hand function. In either case, once you have been recognized, you may unmute yourself. I think all of our board members have joined us by Teams, but if you have to leave and come back by phone, I will have to verbally check in with you to see if you have like to be recognized. Finally, all voting today will be taken via roll call. To applicants and public speakers. Public speakers and applicants, you will be called upon by county staff at the assigned time. Pre-registration to speak at today's hearing was requested. We will accommodate any additional speakers only if time permits. Public comment will take place within the time frame stated earlier, the same as we would provide in an in-person meeting. During public comment, a speaking timer will be displayed on the screen by staff. If you are dialing in by phone and unable to see the screen, we will provide you with an audible warning when 30 seconds are remaining. You will be muted when your time has concluded. Lastly, this is a public forum. Today's meeting will be recorded and posted to the county's website. All information associated with today's meeting, whether written or spoken, is subject to the Freedom of Information Act requirements. This concludes the very lengthy introductory comments. Mr. Rizzi, could you call the first agenda item?
I will, Madam Chair, but before I do, I was just going to ask Mr. Melnick if he was aware that his video seems to have been turned off.
Is Mr. there? We see him. There he is.
And he's back. All right.
All right. Thank you, Mr. Rizzi.
Case number V-11537-20-UP-1 is a use permit request by Edward E. Bintz, the owner, to permit a left side setback of 1.1 feet to the window well instead of 5 feet as required from the left side property line, and a right side setback of 3.4 feet to the areaway instead of 5 feet as required to the right side property line, regarding a proposed window well and areaway modifications in the R5 zoning district on the premise known as 922 North Cleveland Street. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions.
Mr. Rizzi, are there speakers?
The only speakers we have for this item would be the applicant, Edward Bintz, and his agent, John Henson.
Okay. Any questions for staff?
Chair, this is Paul Melnick.
Yes, Paul.
Yes, so I have a question. So in the staff report, it mentions that at least one of the surrounding properties is smaller than the setback the applicant is requesting of 1.1 feet. And I didn't see that on the grid. Is that, yeah, so Stephen, can you give us the location of the one that was being referred to, the one that is smaller than the setback of 1.1?
Mr. Melnick, offhand, I can't find that reference. Let me see if I can figure out where that was. Unfortunately, Mr. Melnick, I don't have that information at this time.
Okay.
Are you talking about the main footprint where it says there are two that have 0? Is that what you're talking about?
Me? Actually, I'm talking about where it says side setback distances in that grid, in the paragraph right above that. So,
Can you read the line where you're at?
oh yeah, so where it's the, let's see.
Page 3, right?
Yeah, page 3. It's above the
table.
The table that says side setback distances, and the sentence is 1, 2, 3, 4, 5 lines from the bottom. It's where it says, and at least one that is smaller than the setback the applicant is requesting for their proposed window well.
Oh, yeah.
See, and that's what I was saying, is it doesn't look like there's anything on here less than 1.1 feet. So that was my issue. But if it is what it is.
That's an unfortunate step there.
Good catch, Mr. Melnick.
That's very political.
It's out there somewhere. I'm just not sure where.
Yeah. Yeah, it's just, it's always good to see how close it is.
Mr. Rissy, are you pursuing this?
Yes, I am. I don't know that I'll be able to get it for you in a timely manner, though. If there are other questions, or if we would like to hear from the speaker, it may be.
Are there any other questions, Mr. Rissy? I have just a small one. The tax map shows the next door neighbor to the left facing as 916. But the letter we have a letter from a neighbor at 918. And I'm wondering if that's the same address. And I can ask the applicant too. But
I think that might be a good question for the applicant.
Okay.
But I don't know the answer.
All right, let's
Yeah,
turn to
it
let's turn to Mr. Bentz. Welcome.
Yeah, thank you. Yeah, I think that was an error on my part. I think I just assumed all the addresses next door were usually in multiples of 4. And
Oh.
So it is the neighbor directly next door to me. So it was my error in
Okay.
preparing the letter.
That's Mr. Humadan?
Yeah.
Mr.
Exactly.
L. Humadan. Okay. Thank you. Anything you'd like to add on the application?
No, I guess to the extent of the 1.1 feet, I would think it'd be a distinction between, a window well, it's going to be a couple of inches above ground versus the wall of a full addition. But other than that, I think my statement and Stephen's summary covers it, but I'd be happy to answer any questions.
Okay. Any questions for the applicant? All right, any discussion?
Madam Chair.
Yes, Mr. Owen?
So I do think that as we're examining compatibility with the surrounding structures, it's not a mechanical analysis to see whether or not there's at least one thing bigger and at least one thing smaller. And I agree with the applicant that it makes sense to compare like to like. A window well and a building wall are not the best comparisons. Mm-hmm. So it seems to me that the 1.1 foot setback taken in the totality of what else is in the neighborhood and the characteristics of the immediately surrounding properties is compatible and would not stick out in some way that reasonable people would notice as a matter of course. So I'm prepared to support the application.
Mr. Owen, would you like to make a motion?
I'll let someone else start us off this evening.
All right. Ms. Freshman. You're muted. Sorry.
There we go. I move the Board of Zoning Appeals approve the attached proposed resolution approving use permit V-11537-20-UP1, subject to the conditions listed.
Is there a second?
I'll second.
Mr. Melnick?
Yeah.
Madam Chair.
Mr. Owen?
Oh, sorry, it was Mr. Melnick wanted to make a comment.
Mr. Melnick?
Actually, you must have ESP, Mr. Owen, but I did want to say basically that was a great point you raised about compatibility, the window well versus a wall, and it's very true. And so that does, it would be interesting to see what would have been in the table. However, it's an excellent point that here we're just dealing with something that's a couple inches above the ground. So I just wanted to, just express that I'm very impressed with that analysis, and I agree with it.
Mr. Melnick, were you seconding the motion or did I put words in your mouth?
Yes. No, I was seconding it. And then I also wanted to comment on Mr. Owen's comment.
All right. Any further discussion? Oh, Mr.
Yes,
Owen.
Madam Chair. I'd ask unanimous consent to add an additional condition. Pursuant to our discussion from the last meeting about zombie permits floating around after the epidemic is over, I ask unanimous consent to include a new condition number 2, which fits nicely in between the existing 1 and 3.
I see it, yes.
The applicants will obtain a building permit to construct the structure permitted herein by August 12th, 2023, or this use permit is null and void.
Hearing no objection, that's included in the resolution. Mr.
Madam
Rissy?
Chair,
Yes.
I think I have an answer for you.
Okay.
So there's an error in the table. The first item under the side setback distances, 733 North Danville Street. The side setback should be 0.85 feet and not 8.5 feet.
Zero.
BZA in case V-9790-04-2.
Excellent. Well, that cinches it.
Consistent with how those tables are usually formatted in order of distance.
All right. Any further discussion? I will call the roll. Mr. Owen? How do you vote? Ms. Freshman?
Aye.
Mr. Melnick?
Aye.
Ms. Clark?
Aye.
Chair votes aye. The motion passes 5-0. The use permit is granted. Thank you, Mr. Bintz.
Okay, thanks, everybody.
Will you call the next item, Mr. Rissy?
Yes. Case number V-11538-20-UP-1 is a use permit request by Diana Burgess, the owner, to permit a street setback of 19 feet, 18.5 feet to the eaves, to a front porch from the 22nd Road North Street right-of-way instead of the 21 feet to the porch, 19.5 feet to the porch eaves as required, regarding the addition to an existing non-conforming one-family dwelling in the R6 zoning district on the premise known as 6311 22nd Road North. Staff recommends that the board adopt the proposed resolution granting the use permit request with conditions, and I'd like you to please note there is supplemental material for this case that came in after the application packet was assembled and printed. It includes an email from the applicant and a photo showing the porch on a structure across the street.
Thank you, Mr. Rissy. Any questions for Mr. Rissy? All right. Is the applicant with us, Ms. Burgess?
Yes.
Did you turn on your video?
Yes.
There you go. Thank you. Anything you'd like to add or let us know about?
I think my application is sufficient, and if you have any questions for me, I'm happy to answer. And I also have my agent here as well.
Mr. Rissy, I failed to ask you if you had any speakers on this item.
The only speakers we have are the applicant and the applicant's agent,
Okay.
both of whom are now on video.
All right. Any questions for the applicant?
Madam Chair.
Mr. Owen?
On the financial disclosure form, there's an indication that the home is owned by a trust and the name of the trustee is listed. However, the form requests the names of those with an equitable interest in the property and not merely those with a legal interest. So I'm wondering if you can provide us with the names and residence addresses of the current beneficiaries of the Palmyra M. Caravetta Irrevocable Trust.
Yes, sir. It's the Palmyra Caravetta Irrevocable Trust, and I am the only beneficiary.
Thank you.
All right.
I have an additional question, Madam Chair.
Go ahead.
It does not appear that we got written feedback from the neighbors on the cul-de-sac at 6317 22nd Road and 6316 22nd Road. And I'm wondering if the applicant, ma'am, if you could describe your outreach to those particular neighbors to consult with them on this project.
Can my agent speak on this question?
Yes, that's fine.
Good evening, everyone. I'm Diana Burgess's agent. I personally drafted the letter up and passed it out to each person surrounding that cul-de-sac and behind Miss Burgess and adjacent to the property. And then I went back even a second time to knock on the door to give people, the neighbors, time to look at the letter and, you know, kind of gather their thoughts on the project. When I went back, between the time that I passed out the letters and went back, we did receive some letters back, a couple of letters back, and then but my intent to go back around was to try to, you know, really try to get a hold of people that didn't turn any letters in. I had, you know, in that cul-de-sac, I had a few neighbors that did answer the door and spoke to me and asked me about the project. Even one particular neighbor that had just recently had a project built and permitted, and they were all for it. A couple of them just did not want to be in the radar of the board for some reason. I don't know. But that was just the kind of like what I was getting, but no immediate or direct objection to the project. A lot of people were excited about it because, you know, they felt like it would update the look of the property, especially when a lot of the houses in that cul-de-sac have already been updated and, you know, remodeled.
Thank you.
Any other questions? I'll ask one. The neighbor across the street from you said that he approved of your effort, assuming, or no, I'm not sure if he was across the street for you, but he referred to the residents across the street from you in terms of quality of materials. Mm-hmm. And I know that I think you sent us a picture of that neighbor, right?
Yes.
How do you, what is the purpose of us seeing this picture?
Well, to really give you an idea that we're trying to not build something out of the ordinary, that it's already been built directly across the street. We are going to build this structure. There's many reasons why we're building it, but one of the main reasons is that we are going to be using comparable materials such as composite decking boards, stuff that's up to today's standards. But we wanted to show you, the main reason was to show you that we're just trying to build something that already has been what we feel like approved. We even measured the structure, and it was past and I know every lot's a little different, but it's pretty much what we're trying to build. So we're not trying to do anything crazy or out of the ordinary. And one of the main things, the reasons why we want to do this is because that the current stoop condition is hazardous, and Mrs. Burgess's mom, who's elderly, recently has a need to use a walker now. So to get from the carport to the front door, it's very hazardous in its current condition. So this is going to really help her out, improve the look of the property, and we're not doing anything that's out of the ordinary. That's what the purpose of that picture was.
Okay, so it was more for dimensions rather than materials?
No, it was more to show the board that this is what we're trying to achieve.
The material wise?
Design wise, mostly.
Okay. Okay. Any other questions?
Madam Chair, this is Paul Melnick.
Yes, Mr. Melnick.
If there, let's see, if there are no other speakers, I'm prepared to make a motion.
Go ahead.
Okay. in case V1153820UP1, I make a motion that the Arlington County Board of Zoning Appeals adopts the attached proposed resolution granting the use permit request with the conditions as stated, including the condition as earlier stated by Mr. Owen concerning the expiration of the use permit. And I don't know the easiest way if we have to recite that each time, or if we can just refer to it. I don't know what the board's preference is on that, but that's my motion.
I'll second the motion.
Mr. Rissy, should we state the complete motion every time?
I'm fine with you referencing it.
Okay, so you have the language for the first one. It'll be the same language for the rest of them. And it will be number 4 on the list.
Let's see.
Yes.
Okay.
Yes, that's fine.
Okay. I will call any discussion on the motion. If not, I'll call the roll. Mr. Owen,
Aye.
Ms. Freshman,
Aye.
Mr. Melnick,
Aye.
Ms. Clark.
Aye.
Chair votes aye. The motion passes 5-0, granting the use permit. Thank you very much.
Thank you.
Thank you.
All right. Bye-bye.
Bye.
Mr. Rissy, next item.
Case number 3-11539-20-UP-1 is a use permit by Christopher Jones, the owner, to permit a rear setback of 19 feet to the deck instead of 21 feet to the deck as required from the rear property line, regarding the replacement of a screen porch previously approved by the BZA and a new deck in the R10 zoning district on the premise known as 2823 North Yucatan Street. Staff recommends the board adopt the proposed resolution granting the use permit request with conditions, and I would like you to note that there are additional speakers who have signed up to speak on this item.
All right. There are speakers that signed up in advance of the meeting, right?
Correct.
Are there any speakers, anyone here that wishes to speak on this item that has not signed up yet? Okay, that's good. Any questions for Mr. Rissy? All right, you can call the applicant.
All right. The applicant is Christopher Jones. If you would please turn on your microphone and video if you have it.
Hi, good evening.
Good evening. Is there anything you'd like to add to your application?
No, I thank the board and the staff for their time on this. I think the application is pretty straightforward. And just as a clarification, Mr. Chu is my agent.
All right. Any questions for the applicant?
I had,
Ms. Freshman?
I just had a question about your immediate neighbors, 2815. It seemed that I couldn't put the email communications and the address together. So I just wanted to be sure that since they're the most immediate neighbor that we had input from them.
Yes, thank you for the question. The neighbor, the owner of the property at 2815 North Yucatan, Ms. Hurd, who does not reside at the residence. I attempted to contact her by email, which is attached in the application.
Right.
Outreach several times over the course of the month and received no response.
Okay.
That was the only contact information that I have from Ms. Hurd.
That was my assumption, but I couldn't link up those emails, that email outreach to that actual address.
Sure.
Any other questions for the applicant? Mr. Rissy, is there other speakers besides the agent?
No, Madam Chair. The agent was the other speaker who signed up.
Okay. All right. Thank you, Mr. Jones. Any discussion?
Madam Chair?
Ms. Freshman,
I'm prepared to make a motion.
go ahead.
I move the Board of Zoning Appeals approve the attached proposed resolution approving the use permit V-11539-20-UP1, subject to the conditions listed and to include a fourth condition previously referenced on a 3-year max.
Is there a second?
I'll second it.
Ms.
So I
Clark,
defer to Ms. Clark.
Ms. Clark seconds the motion. Any further discussion? I will call the roll. Mr. Owen,
Aye.
Ms. Freshman,
Aye.
Mr. Melnick,
Aye.
Mr. Clark, Ms. Clark,
Aye.
and the chair votes aye. The motion passes 5-0. The use permit has been granted. Thank you. Have a good evening.
Thank you.
Thank you. Have a good evening.
Next item, Mr. Rissy.
Next item is case number V-11540-20-UP-1. It is a use permit request by Bruna and Justin Patterson, the owners, to permit a right side setback of 8 feet to the wall, 4.5 feet to the eave of a rear addition from the right side property line instead of 8 feet to the wall, 5 feet to the eave as required, and to permit an aggregate side yard setback of 16 feet instead of 18 feet as required. Regarding an addition to an existing one-family dwelling in the R6 zoning district on the premise known as 6028 Washington Boulevard. Staff recommends the board adopt the proposed resolution granting the use permit request with conditions.
Madam Chair,
Mr. Owen,
before you ask about speakers, I'd like to make an announcement.
go ahead.
One of the applicants, Justin Patterson, on this application is a contractor who I've previously hired to do work on my home. And although that does not constitute a legally required grounds of recusal, given the close business relationship I've had with him in the past, I'm going to choose to recuse myself from this item.
Okay, thank you, Mr. Owen. We've noted that. Mr. Rissy, are there speakers besides the applicant?
No, Madam Chair.
Okay, is there anyone present that wishes to speak on this before we move to the applicant? All right. Is either Bruna or Justin Patterson here?
Oh, sorry. Yes,
we're here.
we're both here.
Okay,
Hello.
Hello.
welcome.
Thank you.
Thank you.
Thank you. Is there anything you would like to add to the application?
No, I think I went over it pretty well. I will note that in the staff packet, when we were deciding to do this project, one of the other options was frankly to tear down the house. It's an old 1942 house. As you can see there, and there's a few reasons why I didn't want to do this. Why I didn't want to do that, even though I could actually build a bigger house. One of the reasons is right in the picture you got up on the screen is that nice oak tree that if we did a tear down, unfortunately, we would lose. So I really feel that I know Arlington's trying to keep its tree canopy. Frankly, by granting us this use permit, you're helping to accomplish that broader goal. I'd also note that in the staff report, there's actually a letter from Arlington's Green Home Choice in support of granting our use permit. Precisely not only because we're going to help keep the tree, but also because of the stored carbon and resources that will be saved by allowing us to do an addition versus a tear down.
So thank you. Any questions for the applicant?
Madam Chair, this is Paul Melnick.
Yes, Mr. Melnick.
Yes, so I have a question about outreach efforts to the neighbor to the left-hand side. I'm sorry, yes, to the left. Actually, if you're on Washington Boulevard,
It's right.
looking at the property to the right-hand side, 6030. I didn't see any correspondence from them. Were you able to reach out to them to get their thoughts on this?
Yes. So a couple of things. Keep in mind that we were one of the unfortunate ones that were on the list for the March meeting. So all of the neighborhood outreach was done in the run up to that. Initially, we had some difficulty scheduling a meeting with her. In fact, I did originally submit text strings to that effect. I just felt that they looked too adversarial. If she should, because we have since met with her and addressed her concerns, and she's like I say, we worked it out, and she's supportive of the project, I believe.
Okay, thank you.
Any other questions for the applicant? I have a couple questions. This is going to be a 3-story home?
Yes.
All right. And it's 3 stories all the way to the back?
Yes.
Yeah, I'd sure like to know so what was the nature of the neighbor's concerns?
The nature of her concern was the nature of her concern was she felt that in the back, by being closer to the property line, we would be crowding out her son. And so what we did is we actually offered to put in solar tubes so she got the natural light that she had before. And she was fine with that.
Okay. And one other, so to build this by right, you don't need relief on the front.
No.
You only need relief on the back corner.
Right.
You could have, so why not just, well, maybe this is a question for staff. If the back corner, because this is a non-conforming, right? Or is it? Is it non-conforming right now?
Yes, I believe so.
Yeah.
And if you don't mind, I can answer your question for you.
Okay.
In my application, I actually addressed that. So we have a crack in the corner of the house that if we were to come in from at the back of the house, so you can kind of see where I fixed the wall and stuff. It's just temporary because, anyway. What we have is we have a crack in the corner. I actually think it was from the earthquake. The house that we procured the house had not had any real work done to it. It was in pretty far disrepair. And that crack, I'm uncomfortable leaving that as the corner of the house with any kind of building on top of it. So by granting us the use permit, we can come back directly from that corner and have a nice new strong corner that anchors the house. And I know your vice chair, Peter Owen, told you I was a contractor. So I kind of looked at that and yeah, I don't like that. I don't want to keep that as a corner because the corner of your house is the most important part of it. So I really would prefer to have a really strong corner, not something that is possibly compromised. It's obviously holding the house now, but if we get this use permit, we can have a very solid corner which to build from.
Okay. Thank you. Any other questions for the applicant? And the discussions with the board.
Madam Chair, I'm prepared to make a motion.
All right, Mr.
Melnick.
Melnick.
Okay, so in case V11542020UP1, I move that the Arlington County Board of Zoning Appeals adopt the attached proposed resolution granting the use permit request with the conditions as stated, and also including a condition 3, which covers the expiration of the use permit maximum 3 years, as stated previously.
Thank you, Mr. Melnick. Is there a second? Ms. Freshman? Ms. Freshman, you second the motion. Are you?
Ms. Freshman, you're muted.
You're muted. Yeah.
Sorry, yes.
You second. Okay, thank you. I will call the roll. Ms. Freshman,
Aye.
Mr. Melnick,
Aye.
Ms. Clark,
Aye.
chair votes aye. The
Madam
motion,
Chair, I abstain.
the motion passes 4-0 with one abstention. Thank you very much.
Thank
Thank
you so
you.
much.
All right.
Have a good evening.
Have a good
All right.
evening.
Have a good evening. Stay safe. Mr. Rissy, you're letting people in. There you are. Would you call the next item, please?
Yes. Case number C-541-20-UP-1 is a use permit request by Sean Alexander Mentis and Caitlin Hone Mentis, the owners, to permit a left side setback of 7.7 feet to the wall from the left side property line instead of 8 feet as required, to permit a setback of 19.2 feet to the window well, 14.8 feet to the wall, 12.8 feet to the stoop, 12.8 feet to the stoop eave, 12.6 feet to the building eave from the 25th Street North right-of-way instead of 25 feet to the wall, 21 feet to the window well, stoop, building eave, and stoop eave, regarding a new second story above existing first floor walls, new stoop, new eaves, and new stucco finish over the entire house in the R8 zoning district on the premise known as 4136 25th Street North. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions.
Thank you, Mr. Rissy. Are there any speakers on this item?
The only speakers we have are the applicants, Madam Chair.
Is there anyone present that wishes to speak on this item? Thank you. Any questions for staff? All right. Do you want to, Mr. Rissy, do you want to call the applicants?
Yes. Sean and Caitlin, you guys can now come forward, turn your microphone and video on if you have it, and address the board.
Welcome.
Thank you very much. Can you see us?
Yes, we do.
Excellent. Yes, my name is Sean, and this is Katie. And been living here for 5 years since we got married. And we're going to be expanding our family in just about 4 months. We were also on that March initial canceled meeting. And we're going to be working from home based on our company's new policies. So we're going to need a little bit of extra room. We worked with a fantastic architect, very familiar with the area and the regulations. And we did our best to stay, to not do too much with, go too much further with the footprint. But as you can see, it's kind of an awkward lot. Meaning that, which is why I think the request seems so long.
Okay. Any questions for the applicant?
Madam Chair.
Mr. Owen.
It seemed to me like there was one neighbor directly across that big street that you may not have heard from, 4137. I'm not sure which street that is. Is that 25th?
It's 25th.
Yeah, it's 25th Street. We're also on 25th Street, and then there's an easement. Actually, I was looking at that, and that's Alan, and he actually signed, but the way his handwriting looks, it looked like he had said 4133.
Oh, I see.
Alan Huffman's at 4137. I think that's meant to be a line 7.
I see. Alan Huffman.
Yes.
Okay.
So he lives at 4137.
Okay. And then, did you, excuse me, did you also try to contact your neighbor at 2319 Stafford Street, who shares the corner with you?
We didn't initially because it didn't abut and you couldn't really see us with some trees in the way, but we went ahead and spoke to him anyway. His name's Justin. He's a really nice guy. He said he was planning on doing a little bit of work too, and he has no issues with our plans. We brought our plans over. We were socially distanced, masked and everything, and he took a look, and he had no issues either.
What'd you say about the trees in between the two properties?
Oh, just that that's why we didn't really initially think to do so, because it's kind of at a catty corner, so we don't actually share. We just kind of have that point. When we were going around with letters, with our letter and talking with people, we didn't originally think to do that. We just went with the two properties that were abutting, and then the folks that could see us directly line of sight across from us.
Is there a lot of? Did you say there are trees in between your house and the house?
Well, I mean, you could just, and that's our side patio right there. All that foliage, and there's just a difference in height. So you can't see their house is all said. It hadn't occurred to us.
Thank you.
Mm-hmm.
It's definitely a challenging lot.
Yes, ma'am. I don't think we fully appreciated that 5 years ago when we bought it, but we're just so excited to be in the neighborhood.
Any further discussion? Are we ready to make a motion?
I'm sure.
Mr. Owen?
I'm prepared to move approval. I move that the Board of Zoning Appeals approve the attached proposed resolution approving use permit V-11541-20-UP-1, subject to the conditions listed, with an additional condition number 3 with the same expiration date as the previous approvals.
3 years.
3 years.
Second? Is there a second?
Second.
Ms. Freshman seconds the motion. Any further discussion? I will call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick?
Aye.
Ms. Clark?
Aye.
Chair votes aye. The motion passes 5-0. Your use permit is granted.
Thank you, Madam Chair. Thank you, Board. We really appreciate it.
All right. Well, better late than never, right?
Absolutely.
Take care. Mr. Rissy.
Yes, the next case is V-11542-20-UP-1. It is a use permit request by Darren and Janice Buck, the owners, to rent street setback 12.7 feet to the porch, 11.3 feet to the porch eve, instead of 21 feet to the porch, 19.5 feet to the porch eve, as required from the 19th Street South right-of-way, regarding a new front porch addition in the R5 zoning district on the premise known as 925 19th Street South. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions.
Are there speakers on this item?
The only speaker we have on this item is the applicant, Madam Chair.
Is there anyone else present that wishes to speak on this item? All right. Any questions for Mr. Rissy?
Madam Chair.
Mr. Owen.
I was curious about the comparison properties that were offered in the staff report. A lot of the properties that had the smaller street setbacks were pretty far away and not necessarily immediately surrounding this property. But I did notice on the tax map that the parcel immediately behind this property, 924 18th Street South, did look like it might be closer to the street. And I was wondering if staff happened to know the distance from the street right-of-way for that property that abuts this property as a comparison.
Offhand, I do not know that, but I will try to get you a prompt answer.
Good.
Anything else? Any other questions for Mr. Rissy? I had one, Mr. Rissy. I know you're working on that. The plat that we're looking at looks like it's from 1967. Is that a concern? Do you, for down the road in terms of measurements later?
Madam Chair, it's not a concern for staff. Staff's position is that we're willing to accept any registered plat that an applicant has to submit to us. We do recommend having one done within the last 10 years. And when we have older plats, we do try and let the applicants understand that they're responsible for the dimensions that they give us with their application materials. So if there are any errors, they have to accept that. To Mr. Owen's question, I have found a plat, again, from the 1980s. This one is, oh, nope, sorry, 1972. That shows the property behind 924 18th Street South having a 15-foot setback to the porch.
Thank you, Mr. Rissy.
So that fits
Madam
in.
Chair.
Mr. Melnick.
Yeah, so it looks as though it's close, but it looks like it may be 1987 for this plat, so that's a little newer than 67.
67, okay, maybe I'm reading it wrong.
Yeah, it looks like it could be an 8 or 87.
Mhm.
So that does
Okay,
make it
that
newer.
makes it, all right. Well, maybe the applicant will know that. Any other questions for Mr. Rissy? All right, I will just, are you Mr. Buck?
I am. Thank you for having me. I'll let you get the timer set. I'm Darren Buck. I'm one of the homeowners. I'm a March alumni. I'm a member of County's Transportation Commission. So as stated in the application, we want to do a covered front porch for this 1925's Craftsman as a part of some other external renovations that we want to do to sort of try and restore some of the aesthetics and usefulness of the house and get some of the elements back that were renovated away back in the 80s. So the front of our house faces due south, so outdoor shade is rather important as our climate inches upward. And the last 7 months spent at home since we submitted the application, we've been interacting with our neighbors far more in the past, and it's sort of reinforced how much our home would be enhanced by having a porch where we can actually interact in the way that the Craftsman movement sort of intended. Sort of mimicking the form of a lot of the existing older homes in the neighborhood that sit closer to our compact street is something I think we should encourage within the discretion allowed by our ordinance. Maintains sort of the older, more intimate, more community-facing form. And similar to a theme that was hit on by a previous applicant, it sort of helps make our historic home just a little bit more livable for our family, and making our older homes more livable seems like a good way to help preserve the dwindling stock without resorting to prescriptive preservation statutes. I should mention some of the questions were referred to us by Mr. Rissy about the property behind us. I did a little field measurement rough with a tape measure today, and I think my measurements of 924 18th Street line up with Mr. Rissy's plat information. It was 21 feet from the curb face to the edge of the eave. However, the public space setback from the curb face to the fence line is, I think, 6 feet as opposed to 8 or so feet on our street. I also took a measurement of another property you'll see on the parcel map, 905 19th Street, which is one in from the corner lot. That one, it's again, these are tape measure measurements, 22 and a half feet from curb face to the end of the porch. I don't know what the public space easement is there, assuming it's the same feet. That would be 14 and a half feet to the porch, but their eaves are projecting out pretty far. So I'd estimate that a comparable number to our 11.2 would be they are right around 12 feet even from, assuming their public space line is similar to ours, 8 feet in to the edge of the eave. We also had a question about outreach to our next door neighbor at 929. We didn't receive a response at the time of the original outreach. She had just moved in after her father had died and probably overlooked it. We reached out by text earlier this week after getting the question, and we got an affirmative response by text. I can email that to Mr. Rissy right now if that would help. And finally, regarding the plat, we did get an updated plat back in February or January. So yes, we do have a current plat.
And the measurements line up pretty much with the old plat?
I have not looked at it and I don't have it handy, but yes, there was no big surprises that I can remember.
Okay. Yeah, it's really for your protection.
Sure, sure.
Any other questions for the applicant?
Madam Chair, just a couple things. I think it would be helpful if Mr. Buck sent the text from his neighbor to Mr. Rissy for the record.
What is the name of that neighbor?
Her name is Gretchen. I can't remember her last name. I'm sorry.
Okay.
She does live at 929. And frankly, I don't know if she is the legal owner yet. I don't know where the house may be in any sort of probate process. So take that qualifier for what it is.
Okay.
And I also just want to thank Mr. Buck for the extra efforts that he took and that Mr. Rissy took to try to find those additional measurements, which are very helpful to moving this all along, in my opinion.
Yeah, the tax maps are not definitive, but they sometimes give you a clue as to where to look. Any other questions for the applicant? All right, discussions with the board. Any further
Madam Chair?
discussion? Yes, Mr. Owen?
I have some discussion. I would just point out that this is another example of a porch built on a porch. So the history of this house is that there was the house and then someone built a porch, and I think they even got a variance to build the porch, the front porch, and then got permission to enclose the porch. And now that the enclosed porch has been fully incorporated as if it were part of the main house, a new owner says, well, I should have a front porch on this house. And we, in Arlington County, we have a policy, as we all know, favoring front porches, open front porches. And so we're sympathetic to wanting them to be built, but I just feel a little uncomfortable every time the consequence of someone's coming through and saying, well, I already have a porch, I just want to screen it in and make it a 2-season porch, or I just want to put windows in and make it a 4-season porch. And the next thing you know, like this house, it becomes part of the main house. And then in order to fulfill our policy of having front porches, we have to grant additional right-of-way type setbacks. So I believe our practice is to try and take a hard line on the enclosure step. And so maybe the Board of Zoning Appeals should not have been so accommodating to the previous owner when they wanted to enclose their porch. I think the steps to this property are awkward because they were steps to a porch and they don't look like steps to a house. I don't know if that's true or not, but seems a likely story. But that said, you know, I do feel a little more comfortable with the extra measurements we got tonight to say that there are setbacks elsewhere in the neighborhood that are similar, maybe not quite as extreme as what's being proposed on this second order porch. But I do feel more comfortable now than I was going into the meeting. That's those are my comments.
Any other discussion? Can we move to a motion? Ms. Freshman?
I move the Board of Zoning Appeals approve the attached proposed resolution approving the use permit V-11542-20-UP1, subject to conditions listed with the addition of condition number 4 as discussed with a 3-year limit.
Is there a second?
I'll second. There's Paul Melnick.
Mr. Melnick seconds the motion. Any further discussion? I will call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick?
Aye.
Ms. Clark?
Aye.
Chair votes aye. The motion passes 5-0. The use permit is granted.
Thank you all very much.
All right, thank you. Take care. Mr. Owen.
Yes.
Sorry, Mr. Rizzi. I got distracted by the people coming in.
I felt like the teacher was calling on me by surprise. Yes,
There's a
ma'am.
quiz.
Pop quiz.
Yeah, I'm watching the names of people as they're coming in, and it's a little distracting. Mr. Rizzi, could you call the next item?
Yes, the next item is number V-11543-20-EP-1. It is a use permit request by Jason and Nancy Routson, the owners, to permit a street setback of 12 feet to the wall, 11.4 feet to the eve from the 11th Street North, instead of 25 feet to the wall, 21 feet to the eve as required, for a 1-story and 2-story rear addition on a corner lot in the R6 zoning district on the premise known as 1101 North Potomac Street. Staff recommends the Board of Zoning Appeals adopt the proposed resolution granting the use permit request with conditions.
Okay, are there any speakers?
Madam Chair, the only speakers we have for this item are the applicants and their agent, Roger Bull.
All right, is
Madam
there any?
Chair,
Mr. Owen?
were there supplemental materials for this item?
I do not believe we have supplemental material for this.
Not seeing it.
Okay.
No.
Oh, right. I'm sorry. I was looking at the map and I was confusing it with another application.
Yeah, that's right. Is there anyone here that wishes to speak on this item? All right. Questions for Mr. Rissy. Ms. Rissy, I have a question. Just orient me again to what is the back and what is the front on how we determine that.
Madam Chair, on corner lots, the shortest frontage is the front. So this would be the front. The side opposite the front is the rear. So this would be the rear. And anything that isn't a front or rear
is a side. All right. Thank you. All right. No questions for the applicant or for the staff. Let's hear from the applicants. Good evening. Welcome.
Hi, I'm Jason Routson, and this is my wife, Nancy. We just want to thank the board and all your volunteers for a thorough reviewing of our proposal.
Hi, thank you again for reviewing our proposal and considering our application.
All right, well, we're happy to have you here. Any questions for the applicants?
Madam Chair, I'm prepared to make a motion.
Mr. Owen.
I move that the Board of Zoning Appeals approve the attached proposed resolution approving the use permit V-11543-20-EP-1, subject to the conditions listed with an additional condition number 4, imposing a 3-year expiration.
Is there a second?
Second.
The motion has been made and seconded. Any discussion? I will call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick?
Aye.
Ms. Clark?
Aye.
Chair votes aye. Motion passes 5-0. Your use permit is granted.
Thank you all.
Were you from March too?
Yes. Oh, no, we were April.
April. Okay. Well, we're making
Yeah,
progress.
we're making progress.
Thank you all so much.
All right. Take care.
Thank you.
All right. Bye-bye. Call the next item, Mr. Ritchie.
Case number V-11544-20-UP-2 is a use permit by John and Kate Newell, the owner, to permit a rear setback 8 feet to the wall instead of 10 feet to the wall as required from the rear property line, to permit a setback of 18 feet to the canopy eave instead of 21 feet as required from 16th Road North, regarding a 2-story rear addition and multi-tiered deck and new left side entry canopy on a corner lot in the R8 zoning district on the premise known as 1624 North Greenbrier Street. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions. And I would like you to please note that there is supplemental material for this case that came in after the application packet was assembled and printed. I believe it is some additional outreach from the applicants.
Thank you, Mr. Rissy. Are there Are there speakers?
Madam Chair, the only speakers we have for this case are the applicants and possibly their agent, Ms. Riddle.
Is there anyone else here that wishes to speak on this item? Okay, Ms. Freshman?
Yeah, I noted at first, before the tsunami of this afternoon, that we had not had updated outreach, which I'm happy to have even at the last minute. Is this essentially the same application? I wasn't able to discern if it was demonstrably different from 2018.
Ms. Freshman, I believe that it is, but I do think the applicants could probably give you a much better answer to that than I.
Okay, thank you.
All right. Let's see, the applicants are John and Renee Newell. Are you here? Yeah, there you are.
Yes,
Welcome.
we are. Madam Chair, thank you so much, and to the board. Just to give you a little background, this project has been in the design stages for a couple years, and through our agent, our architect, Sarah Riddle-Mosier, who is here with us tonight. And we have just decided to go forward, and we are a March alumni as well, waiting patiently for the board. So thanks for the opportunity. We have updated our outreach and are prepared to speak to that. But the basis of the project is to replace an outdated and poorly constructed sunroom with a modern family room, and then an additional art studio above that. So Renee's an artist and going to give her a dedicated place for her art. And then replace a dated and weathered wooden patio porch or a deck with an updated and modern deck. And you can see the yellow room we're attempting to replace on the back. And happy to answer any questions.
All right. All right. Any questions for the applicants? I guess the question was, I'm sorry if I missed it, I was looking at your neighbor sign-offs. Is this the same application that you submitted before?
It's the same, save for some placement of the windows. Sorry, another participant there. So we've just modified the placement of the windows on the addition, and other than that, everything is the same.
Okay, thank you. Any other questions for the applicants? All right, the discussions with the board. Any further discussion?
Madam Chair, I'm prepared to make a motion. This is Paul Melnick.
Mr. Melnick.
Okay, so in case V11544420UP2, I move that the Board of Zoning Appeals adopt the attached proposed resolution granting the use permit request with the conditions as stated, including, let's see, a condition number 3 with the 3-year maximum that we referenced earlier.
Okay, condition number 3. Is there a second?
Second.
Seconded by Ms. Freshman. Any further discussion? I will call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick?
Aye.
Ms. Clark?
Aye.
Chair votes aye. The motion passes 5-0. The use permit is granted.
Thank you so very much.
Thank you very much.
Good luck with your project.
Thank you. Appreciate your time.
Okay, Mr. Rissy. Next item, please.
Yes, before I call the next item, I just wanted to ask our guests, if you are just joining us, we need to ask that you keep your cameras off until the item that you are interested in speaking on is. Thank you. Next item is case number V-11546-20-UP-1. It is a use permit request by Ariane Lazak, the owner, to permit a street setback of 21.2 feet to the wall instead of 25 feet to the wall as required from North Columbus Street, and to permit a street setback of 16.3 feet to the post of the carport and 11.2 feet to the porch instead of 25 feet to the carport, 21 feet to the porch as required from Second Road North, and to permit a rear setback of 6.1 feet to the wall of the attached shed from the rear property line instead of 10 feet as required, regarding a new addition, porches, carport, and shed on a corner lot in the R6 zoning district on the premise known as 251 North Columbus Street. Staff recommends that the board adopt the attached proposed resolution, partially approving and partially denying the use permit request with conditions. 2 alternative proposed resolutions have been provided should the BZA see fit to approve the case as advertised or with a modified rear setback of 6.5 feet. Now, and I'd ask you to note that there is supplemental material for this case that came in after the application packet was assembled and printed, and we have had an additional speaker who has signed up to speak on this item.
All right, so besides the applicant and that additional speaker, do you have a name for that?
Yes, it is Anthony Clapper.
Okay. Is there anybody else here that wishes to speak on this item before we move along? Thank you.
This is Ariane Lezak, and our architect Greg Kearley is also on the line.
Okay.
Hi, this is Greg here.
We will get to you in a sec. I was just checking if there's anybody else here any of your neighbors or anybody else here that wanted to speak. Are there any questions for staff?
Madam Chair.
Mr. Owen.
First, just for the record, Mr. Rissy, could you describe the nature of the supplemental materials?
The supplemental material was a letter from the adjacent, or from one of the surrounding neighbors, I believe.
At 4811?
A letter in opposition?
Correct.
Okay. And then additional question, the staff report indicates that this parcel received a variance in 1987, but that variance was partially denied. And the staff report describes it as requesting a side setback of 4.66 feet that was denied. At that time, this parcel had a different street address. And so I'm wondering which side of the property was there a 4.66 foot setback sought and denied?
Mr. Owen, I was unable to do the research to find the 1987 application to the BZA, but I have had some conversation with the applicant's agent, and I believe he has seen some old plans and may be able to speak to that question.
Okay, thank you.
That's all. Would you like me to do that now?
Okay. I have no further questions for staff at this time.
Any other questions for staff? All right, let's hear from the applicants. Ariane, Lisa?
Yes, this is Ariane. Thank you for taking the time to hear our case today. We really appreciate it. I'm here with my husband, Peter, and we bought this house about 4.5 years ago and absolutely loved that it was such a focal point of the neighborhood. And we've always felt that there needs to be something making it stand out a little bit more in front. Our understanding was there was a beautiful, tremendous tree right in front before we purchased it, and that trimming the tree was $4,000 to the prior owner and cutting it down was $2,000. So they got rid of it, and which was heartbreaking to us, but we thought, well, we should do something else then to make it stand out as this beautiful, welcoming piece up that large main thoroughfare into our neighborhood and up to our corner. And then right behind us, the next corner starts the absolutely tremendous new community center. So it's really a very welcoming way to see things and to progress through the neighborhood. So we hired Greg because we wanted something that kind of fit in with the aesthetic of the neighborhood and keeping in mind also the community center. So I will happily turn it over to Greg to explain some of his ideas.
All right. I also, Mr. Owen, would you like me to explain what I found out about the previous Board of Zoning case?
Sure, that'd be great. Thanks.
Okay. So in looking at the old plans, as you're looking from the street to the face of the house on the right, it looked like there was a garage being proposed there. We see foundation plans and block walls. I didn't see the elevations in the old plans, but there was clearly a garage proposed for that location. And that is the same location that we are proposing the carport. The difference is the garage was enclosed and much larger. We are proposing a carport, which is much more open and lighter in feel. So I believe that is, and because of the change of address, the side yard is now the rear yard and the rear yard is now the side yard. If that makes sense, because we're on a corner lot.
So if I'm looking at the the architectural plat, this piece, this drawing,
sure,
where it's showing the footprint of the new structures, it's in the position. What the old application was in the position where you have stated additional garage. That's where the garage was previously proposed.
I believe so. I couldn't find the actual case. I'm looking at some old plans, and in talking with Stephen about that, and that's what I sort of gleaned as much as I could, that the location of our proposed carport, there was a proposed garage at some point.
Oh, and as I look at this more carefully, I have another question I'll have for staff, but I don't want to interrupt the rest of your presentation if you have more to say.
So I don't know if we can get to the image of the proposed addition and front porch, but this is on it's a unique lot because of the geometry of the lot. And
Greg, would you like us to, if we could share our screen, we could put up the image he's speaking of. Is that possible?
Mr. Rissi has it too, right?
I believe.
I believe so, yes. Is there any way to get that up?
What image are you looking for?
The rendering, which shows the proposed front porch and open porch in the front and screened in porch on the side. I'll just
be mindful of your time. I think we've got a timer going for somebody
what we
here.
were looking to do was creating something that would be inviting for the neighborhood. By having a screen porch, we would get eyes on the street. It would connect to the neighborhood. We believe it balanced out the house, which was very boxy. So by creating an inviting screened-in porch, an open porch, and small addition, that was the intent of the design. And we also thought that the carport balanced the composition and created a more holistic design. So that was the intent of that, and you can see the images here. I just saw my timer running out, so
yeah.
I went through that as quick as I could. So thank you.
All right. Well, we can. I'm sure we'll have questions.
Sure.
I have a question. I'll just start. I have a question on the neighbor input that you have from Anthony Clapper at 411 North 2nd Road. That is we received that. Are you aware of this email that we received?
I am not.
All right. Do you know Anthony Clapper?
We do.
Okay. He lived, according to this.
It's our next neighbor.
Oh, yeah. Mm-hmm. We spoke with him.
I'm a little confused. I thought in your neighborhood testimonials that there is a Sam Smart that lives at 4811.
This is Tony Clapper. If I can jump in and just clarify that point, if that's helpful to the board.
Whoa. Oh, Mr. Clapper, are you here?
I am, and I don't mean to jump in, and happy to make my comments quickly and cede some time to Ms. Lezak. But just to answer that question, it was confusing to me too, but we saw the submission from a Sam Smort or something.
Yeah.
We thought that was 4811 too. We think it's 4814, which would be the neighbor across the street.
Okay.
Now, that's a rental unit, so I don't know if that's a renter or the owner,
Okay.
but that's not us.
Okay.
The Clappers.
Thank you.
I'll shut up until I'm called.
All right. Well, thank you for, yes. That was my question. So that's 4814. So,
Madam Chair,
yes, Mr. Owen.
I didn't realize that we still had a neighbor to speak. So are we on track to hear the speakers, or are you still questions for the?
We're still doing questions for the applicants, but and then we'll we'll hear from the speakers.
Okay. Sorry.
That's all right. Any other questions for the applicants?
Yeah, so I actually had a question. This is Paul Melnick. Okay, so my question is, you can see in the staff's report, in their analysis, when they put together the table about the setback lines, when they were discussing the proposed rear setback to the wall of the attached shed. So the application wants a setback of 6.1 feet, but the close or the staff was basically coming to the conclusion that this may not be compatible, and what they found is 6.5 feet for a porch and attached landing. And what I'm wondering is, the saying here about feeling as though the 6.5 would really be what's compatible instead of 6.1. How feasible would it be to adjust the plans to make them 6.5 so that they're more in line with what staff found in the surrounding area?
I think that would be something that we could do. I don't think that would. We're talking about the shed at the carport.
Yes.
Yeah, that could easily be brought back. What is it's 3 some feet, 0.3 something feet, right? So you're not talking a lot, right? It was 6.5 compared to 6.1.
Exactly.
So that would easily be done, and we could alter that proposed shed and bring it back within that would be no problem.
Okay. Yeah, so that would make it match, what the staff was saying. So that's appreciated.
Sure. Yeah, that would not be an issue, and I don't mean to speak for the client, but to bring it back those few inches is not an issue.
Yeah, it's fine.
Madam Chair.
Mr. Owen.
Just a quick question for staff and then another for the applicant. The plat shows a utility easement on this property line. Mr. Rissy, does this utility easement have any impact on any of the discussion that we're having? Can we ignore that, or do we have to pay attention to it? Mr. Rissy?
Mr. Owen, I don't believe that it impacts the zoning of the structure in any way or any of the zoning required setbacks.
Okay, so it might affect some permitting outside of our zoning appeals purview.
It could, depending on the type of utility that it is, but
okay,
it wouldn't affect the zoning.
Thank you.
I'm sorry, may I follow up? Mr. Rissy, when you say it may impact the permitting, do you mean to say that it might not be able to be built as shown?
That's possible. It depends really what the type of utility is, whether it's used actively and the setbacks necessary from that easement. I mean, obviously there are all types of utilities and there are all types of required setbacks from them, and I'm unsure of what's there or what would be required from it.
Okay. Mr. Owen, you may continue.
Thank you, Madam
Thank
Chair. My additional question for the applicant is, actually, could I also add, Mr. Rissy, if you have not already done so, could you please be sure to transmit the letter that we received from the neighbor to the applicants so that they have it during the hearing? I wouldn't want them to be missing any information that's before the board. But if I could briefly summarize, Mr. Curley, or the Mr. and Ms. Lezak, basically the neighbor is suggesting that it would be better for an 8 or 10 foot setback from that property line as opposed to the proposed 6.5-ish. So, and I'm wondering if you could discuss as an initial matter what impedes you from building within the by right range on this side of the property. What's the impact on the design or the utility of the project?
Stephen, is there any way to bring up the site plan?
Yes.
The proposed, the one in our package, not the existing.
That one?
Yes, I don't know if you can zoom in on that. It's not a. This is what we're talking about over here, right? And this is where we're asking for the setback. And if we move it back, we don't have enough room for a car, for one. And then if you move it forward to get it within that, then you're getting into the front setback even greater. So it's just the geometry of this site. Here's the proposed carport you can see. And if you start moving that in, you're getting so tight, it would be difficult to get a car in there. And then if you move it forward, you can get within the 10-foot setback. But if you move it forward, you're actually going into the front setback even greater than what we're proposing. So it was sort of a push and pull. I think we could make that carport slightly smaller to get it from 6.1 to 7 or 8 in that range, and we could probably still fit a car in there. But if you start going any farther than that to get to the 10, it won't be wide enough to fit in a car unless you moved it forward and then you're going towards the street. Does that make sense?
Yes, I do. I have one other thought, which I'm not expecting an answer for on the spot, but your description seems to presume that it would remain in a rectilinear orientation to the rest of the house. And I wonder if rotation would also help the situation. But that's just a comment on my part. Thank you. I really appreciate that answer. That's helpful.
It would be something we could look at if we needed to on the carport.
Mr. Rissy, could we have a speaker on this item? Could we bring them up as well?
Yes. The speaker is
Mr.
Clapper.
Clapper.
Yes. Hi, everyone. Can you hear me?
Yes, thank you.
All right. Thank you, board members. And let me just say up front, I'm not trying to create problems for Ms. Lezak or Mr. Neeson, who are our neighbors. But we did not have an opportunity prior to the time they made submissions or afterwards or in their canvassing of our neighbors to speak with them. They did not approach us. We did not see any plans. And we are probably the most directed applicant, or excuse me, the most directed adjacent neighbor in the mix. And so our biggest concern is my wife and I, we've lived in this neighborhood, we've lived in this house for 21 years. About 12 or 13 years ago, we built an addition, moving to the left side of our house towards what is now the Lezak house. We stayed within the zoned arena. We did not seek any variances, but we went right to the edge. So as they move closer to us with this rear, towards the rear property line, with their proposal going from 10 to 6.1 or 6.5. It's just crowding the area, and in the area that is the most sort of aesthetically pleasing part of our house, which is our front porch, our open front porch area. So I would have loved to have had a conversation with them leading into it. I did see the posting on the light pole about this hearing. And at that point, I did approach Ms. Lezik's husband, Mr. Neeson, and asked him about it. He didn't offer to share the plans. That's fine, but I didn't have a full appreciation of what this looked like and how close, and that there was a question about a variance until we pulled up the paperwork. And at that point, my wife and I discussed it. And we also think there's ways to modify this. We think the addition that they're proposing looks great. We're excited for them to add this to the neighborhood. We don't want to impact it, but we also want to protect our interests with our property next door. So this notion of maybe 8 feet, which we propose as a compromise, I'm no architect, but maybe even moving it closer to the front, if that's a possibility, towards the front on North Second Road, maybe that would work with the architect and with them. So again, I apologize to them and to the architect and to the board to be a stick in the mud on this, but it is of interest to us to have the location change slightly so we could have the separation. We think aesthetically, at the end of the day, it's going to be best for both of us to have that physical separation and have the property space, because we've used the full area. So those are my comments, and I'm happy to answer any questions.
Mr. Clapper, we appreciate your coming and speaking. That's the purpose of the hearing, is to hear from all affected neighbors and to get everybody's input. So we're very appreciative of you taking the time to come.
Well, thank you for the time to hear me.
So we talked about a couple of options. One is reducing it to 8 feet. The other is or moving it forward. How are people feeling about that?
Madam Chair?
Mr. Owen.
Well, first of all, I think it seems to be a consensus view that most of the project is great and is widely supported in the neighborhood and has staff support. So we're down to just the part on the right, on the rear side of the property where the carport is. To me, that seems to be the only thing that's really at issue. With respect to that, it does seem like we have on this project the benefit of a very talented architect.
We do.
And a very reasonable sounding neighbor. And I wonder if a discussion with the talented architect and the reasonable neighbor wouldn't produce an outcome that makes everybody happy. And so I oftentimes, when we have this kind of situation, we'll give the applicants and the neighbors some additional time to chat and come up with something that is that works for everyone. And I wonder if that is possible maybe to try in this situation.
Ms. Freshman.
As the architect, I welcome that.
Okay, yep, thank you. Ms. Freshman has a question.
Yeah, I was just going to say that the sticking point appears to be the rear of the carport, which is actually a shed, and there's already a shed on the property. And I'm wondering if by not so much moving the carport, but just eliminating its length and that proposed storage, or perhaps putting the storage to the side, the house side, or some other adjustment would mean that the separation from the corner of the carport, where there's actually a car and nothing else, might provide the breathing space that everybody seems to be looking for.
Unfortunately, I don't know that we can conclude this today. Because Ms. Lezak?
Yes, please. If we aren't able to agree on the carport today, would it be possible for us to approve the other part of the plan so we can start moving forward on it and revisit the carport after we talk to our neighbor?
Well, your plans include a carport, and that's what we would be adopting today.
You wouldn't be able to partially adopt a plan?
No.
Not really, because, and you wouldn't be able to partially build it anyway.
Could we adopt this at an 8-foot setback, and I'll work with my client, Angel and Peter, and the neighbor to meet the 8 feet and adopt it as such?
Madam Chair,
Mr. Owen?
I think the problem is that we can't design the different carport during the meetings.
Yeah,
And-
I understand.
And we typically require seeing what it looks like in design before we approve, because the approvals require that the design be kept, right? So that's the challenge.
I guess in talking with Angel and Peter, do we have to go back into the queue, or can we sort of do this in a quicker time frame? You know, in terms of how do we get to the next hearing? Is it something where we have to go back in line, or can we do this on the staff level, or does it have to be adopted by the board?
It has to be adopted by the board. Mr. Rissy?
It has to be advertised.
It has to be advertised. The new plans have to be advertised. So we go through the process again. Typically, it's 2 months, you know, is our turnaround time. Mr. Rissy, do you see a different path?
Madam Chair, we haven't advertised either one of our September hearings, so both September 16th and September 30th are available to you if you are looking for deferral dates.
That's good.
Obviously, October and later would also be available.
I think September 30th, 45 days for something of this magnitude sounds doable to me. I don't know if Mr. Carley thinks his design work can go that fast, and if the applicants and the neighbors would have time to talk to each other during that time.
We would be able to have an alternative in 2 weeks for the neighbor and my client to go over things.
Okay.
And I, as the as the neighbor, would be delighted and happy to meet at everyone's convenience to discuss. So I work from home, so it's easy. We can do that.
And 3 more weeks to advertise, so that's 5 weeks plus whatever time for discussion. Sounds like it might be possible.
September 30 looks possible. If obviously you don't make it, we just move you on to the next hearing.
Sure. And can I just make a comment too, and see if you agree with this, that there's a high probability, even if we didn't do the carport, that we would have the front porch and screened in porch, et cetera, approved, because it's going to take us 2 to 3 months to do the construction documents. And so we could still move forward if there's the confidence that we feel that we will be granted relief, at least for those parts. Then I can get, you know, all the we're done with schematic, which is only 25% of the work. We have to do the real work. And I think that's the concern of the client.
Ms. Freshman.
Yeah, I think that in my view, at least, what we've all been talking about is just the one corner carport and shed. I think it's a bit of a gamble for you to go ahead and do the work and spend the money. But speaking for myself, I would think that it was not a high risk unless my colleagues object to, not that there's any approval of this board in any way, but that the inclination is such that we're really deferring because of one small part of the proposal. And it's, if you feel confident enough to go ahead with construction drawings and other things, that, because some of those details are still going to have to be presented for the advertisement.
Sure. No, I'm just saying this because I know we're looking at a spring start of construction if possible, and that means that if we're waiting till, let's say, October to get going, and I won't say anything more about that. I'll talk to Angel and Peter about that and give them my best. I have a lot of confidence in this. I think we have a great plan. I think we have a neighbor who's willing to work with us, and we're willing to work with them. So enough said on that.
Mr. Mel, I think our motion would be to defer for the sole purpose of working out that corner. So that could give you as much confidence as I think we can give you.
Sure.
It's implicit, but it doesn't approve the rest of the plan.
Right.
No, understood. And I'll talk to my client about that shortly.
Mr. Owen?
We usually give a warning at this stage in the process that the neighbor does not have a veto over the project. So ultimately, the decision about whether or not accommodations have been reasonable or not are up to the board. But it certainly makes it easier and faster if the neighbor comes in with a ringing approval. Then our deliberations go much easier. So that's preferred, but not necessarily required. And I think, Mr. Rissy, correct me if I'm wrong, but it certainly would be possible to advertise alternatives with the carport and without the carport designs that would give the BZA options in case more discussions were needed and they wanted to get started. Isn't that right?
Traditionally, the BZA has not wanted to see any options, and they want a heads up or down, approval or not.
Really? All right.
Yeah. we're that strict, huh?
Okay. All right.
All
well,
right. I think we're on a track here to move that we defer this to the September 30th hearing for the purpose of getting neighborhood feedback and input on the design of the carport and shed. Would somebody like to make a motion to that effect?
Madam Chair. Madam Chair?
Yes, Mr.
I move that the board, that in case V-11546-20-UP-1, that the Board of Zoning Appeals defer this item to the September 30th BZA meeting for the purpose of allowing more time for consultation with the rear neighbor and design changes along the rear of the property.
Is there a second?
Second.
Ms. Freshman seconds. Any further discussion? I think we've pretty much laid out where we think things stand. Any questions from the applicants or the applicant's agent?
No, ma'am. Thank you.
No, thank you for your time.
All right, thank you. So I will call the roll on the motion to defer. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick? Ms. Clark?
Aye.
Chair votes aye. The motion carries. We are deferring this matter to the September 30th hearing. Thank you very much.
All right.
Thank you everyone for looking at this a second time. Mr. Rissy, next item.
Yes, the next item is case number V-11547-20-UP-1. Is it a use permit request by Erica Marin, the owner, to permit a street setback of 18.8 feet to the porch, 17.8 feet to the porch eve, instead of 21 feet to the porch, 19.5 feet to the porch eve, as required from South Culpeper Street. Regarding a new front porch in the R6 zoning district on the premise known as 2432 South Culpeper Street, staff recommends that the board adopt the proposed resolution granting the use permit request with conditions. And Greg, if you're still there, I would ask that you turn off your camera for us.
Mr. Curley?
He seems frozen.
Oh, he is frozen. Yes.
We'll continue.
All right.
Send him an email.
The moderator has the ability to boot a person from the meeting.
I don't think it would be out of order.
You have to order it, Madam Chair.
Could we dismiss Mr. Curley, and if he wishes to rejoin at a later time, we'll readmit him.
Yes, ma'am.
Besides Ms. Marin, do we have any speakers on this item?
The only other speaker would be the agent, Madam Chair.
The agent. Okay. Is there anybody else here that wishes to speak on this item? Hearing none. Any questions for Mr. Rissy? All right. Want to call the applicant? There she comes.
Yes.
Welcome.
Hi, how are you?
Good.
I guess I should start by just saying thank you for taking the time to hear me out and for your consideration. And the application seems to have, I think, most of the information that you would need. But if you have any questions, I would love to answer them.
All right. Thank you. Any questions for the applicant?
Madam Chair.
Mr. Owen.
Where I'm hung up on this application is not the design or placement, but the condition or the finding, the third finding that we have to make: would the proposal be detrimental to the public welfare or injurious to property or improvements in the neighborhood? And I believe the applicant's property is on a very steep hill. And to some extent that works to the applicant's advantage, because this structure would be partially hidden below the street by the hill in front of the applicant's property. But where I'm concerned is about the properties downhill of this applicant. This will add to potentially to the impervious surface of the property. And we don't have any feedback from the rear neighbors about their feelings about this. And I don't feel like I have a clear analysis of the water runoff improvements that might be being made to this property. So I wonder if the applicant could address two things. One is, what improvements are you proposing to make to reduce water runoff off of your property? And second, what outreach have you made to the properties that share property lines with your property? Thank you.
So we have attempted to reach out to both of the addresses that we were given by Stephen. I'm not sure if it's because of, everything going on with COVID, et cetera, but we haven't had any luck. We had a letter that we prepared and we left with multiple neighbors. We left it in their mailbox on 2 separate occasions. But without, them answering the door, it's kind of outside of our control. We got as many signatures as we could. I think just kind of weird times, so that's to answer that question. We couldn't get in touch with anyone and no one would answer the door. Now, as far as what we would do for the water, I sent a couple of pictures to Stephen. Obviously, it was today, so a little late, but where we've installed a silt fence to have erosion and water control to make sure that there's no water runoff that goes into anyone that's behind us.
I'm sorry, I had a little trouble hearing the key word there. You've installed a what?
A silt fence. It's like I can show you a picture. Unfortunately, I only have it on my phone. I can put my phone up to the camera.
Does Mr. Rissy have a copy of the picture?
He does, but I only provided it to him today.
But if do you have it, Mr. Rissy?
Yeah, I can see it on my screen. I'm not sure if you all can.
Okay.
So we've installed that.
Is that a temporary fence?
Right, to protect the water from running off. So that way there won't be any like mud, water, etc. going into other people's yards. So that is around the entire perimeter to make sure that there's no issues.
I think what I was wondering about was a more long-term issue. So right now in front of your house, there's soil. So when it rains, the water can go into the soil instead of running off, in another direction. But when you add to the size of the structure on your house, the soil won't necessarily still absorb all of that coming off at once out of a drain spout from the roof. And so many times what people will do is install French drains or catchment basins or other kinds of engineering protections that will store stormwater on the property until it has time to drain. And so I'm not sensing that that's part of the current plan for your improvement. So,
to be honest with you, I'm not 100% sure. I've got my husband who's right next to me, but he wasn't noted as one of the speakers, so I didn't know whether or not he could speak. He's much more immersed in the project than I am. If you all will allow it, I can have him come on and talk to you all.
I think that would be fine.
Would that be okay with you guys?
Yes.
Okay, and then Mr. Owen, would you mind repeating what you just said so that he can come on and listen?
No problem. I'm
Bear
happy
with
to.
me one moment, please. Give me 1 second. And I also have to switch off. I have headphones. I got to switch into off headphones. So just bear with us a moment.
Mr. Owen, while she's doing that, are you ready?
No, not yet. Sorry.
Okay.
Give us 1 more minute.
I do note that in the applicant's statement of justification that they mentioned that collected stormwater will be directed by downspouts around the side and to the rear of the site.
That sounds like the opposite of what we would want.
Can you guys hear me?
Yes, thank you. Thank you for joining us.
Yeah, thank you guys for your time. So she tried to explain to me, but
Sir, just before you begin, sir, before you begin, if you wouldn't mind stating your name for the record.
My name is Bruno Vega.
Thank you, Mr. Vega.
Yeah, sorry.
So, Mr. Vega, we were wondering about, as part of this project, are you planning to make any permanent changes to how water runoff from your property will be collected, stored, or reduced from the downhill neighbors?
That's a difficult question. So I know that the silt fence is right now there to prevent the sediment from the original water runoff, the sediment from going into other areas. As far as the downspouts and gutters are concerned, I believe that is going to be in accordance with what is noted in the drawings and approved by the county. But in terms of other sorts of, I would say, water collection things or those sorts of things, is that what the type of question that you're asking?
Yes, it is.
Yes.
Is that a code ordinance for the county to have like?
So my concern. Yes. So as part of these approvals of use permits,
yes, sir.
The Board of Zoning Appeals needs to make a finding that this improvement will not injure neighboring properties. And because your property is on such a very steep hill, a common concern with increasing the impervious surface, increasing the amount of your property that does not have soil on it. It seems possible that this would further increase the amount of water that doesn't go under your property when it rains or when there's a storm, but increases the amount that floods into neighbors' properties. And so oftentimes when people build improvements such as yours, they will add engineering catchments, French drains, storm, I forget the names of all of them. There's a variety of ways to hold the water on the property so that it doesn't drain over into the neighbor's property when you get a rainstorm. And so that's really the inquiry. And it's because we don't have information from your neighbors, although you tried to get information from your neighbors, we don't know their perspective. Do they already get a lot of water, or is that not a problem? We don't know the answer. And so for me, it's difficult to make the finding we're supposed to make tonight to approve you without seeing either information from the neighbors about whether there's a problem or information about improvements to water collection that you would be making as part of this project. That's the challenge.
As far as I know, it's a pretty heavily wooded area around, which is why the disturbance of soil was supposed to be mitigated by the silt fence and the super silt fence.
Yeah,
that's typical for me. I mean, I've been in commercial construction for almost 12 years, and I just recently started residential stuff about 2 years ago. But that's the same measures that we take on a project-to-project basis is disturbance of soil. Prior to that, super silt and silt fence is installed so that we don't have dirty water running all over the streets and into people's yards, because then you start to see this stream effect that happens into people's yards, and then their yards become kind of disturbed and it looks bad. So as far as rain and water collection during the project, I personally have never dealt with that. On large commercial projects, we would build temporary retention ponds, but you're talking about
no,
100,000.
Sorry, I don't mean to be confusing. I'm really only concerned about the long term after it's built issue. So I have no doubt that you've already, I think, to my satisfaction, explained during construction that you're taking sufficient measures. So my issue is after this project is done, there'll be less dirt on your property to collect water than there used to be.
Yep.
And so that's the situation where we often have applicants propose long-term permanent water collection measures to collect the stormwater and drain it much more slowly into the earth.
Honestly, we'll do anything that we have to, honestly. Those types of things are in my mind pretty standard. If they have to be installed, we install them. So if that's something that needs to be done, I can get with the architect, see what's code compliant with the county and with the neighborhood, although there's no HOA there, I don't think. So look for code compliant, reasonable mitigating things that we can put in, and that's what we'll have to do.
Thank you.
Yes, sir.
Any other questions for the applicant? Mr. Rizzi, you have your hand up?
Yes, Madam Chair, the question wasn't directed towards staff, but I feel I could give an explanation from staff's perspective if it would be helpful.
Okay.
So from a staff perspective, I will note that the applicant has not reached either their main building footprint coverage nor their lot coverage. So the issue for us isn't so much about the coverage on the site as it is the placement that they're asking for. Further, the Department of Environmental Services is the department of the county that reviews projects for stormwater. And this project, like all others, will have to meet their standards and will have to do any requirements, as the applicant said, that they feel are necessary.
Well, as we've seen in cases in the past, neighbors do have problems with water, and sometimes we are called to help try to solve them. Sometimes the solutions are as easy as directing downspouts in a particular way. I really don't have a solution to offer at this point. Any other comments? Mr. Owen, are you suggesting that we defer this matter?
I think that's the cleanest solution. Just to have whoever's designing this project consult with private sector engineers and propose an appropriate water retention system. Lots and lots and lots of homes around Arlington do this. So there's very standard facilities that can be built. And maybe they could come back with a proposal for water catchment. I would love it if in the same amount of time we could get the applicants to try again to contact the registered addresses of the neighbors that they couldn't reach, but it does sound like they already made substantial efforts to contact their neighbors, but that would really be helpful too.
So
this is not a very complex, I think it's not a very complex problem. It's a pretty typical issue that we see at the BZA. And I'm hopeful that it wouldn't be too difficult for the applicants to talk to an expert outside of the county staff to make a proposal.
So I would be more comfortable if we had any, right now I don't see any of the abutting neighbors having signed off on, given feedback on this property. Neither the two on the side or the two in the back. That does leave us a little bit in the dark as to what the conditions are.
I actually got into today. I sent an email to Stephen with the two neighbors on the side. Again, the only ones we couldn't get were the neighbors in the back.
We have supplemental material on this, Mr. Rizzi?
No.
Madam Chair, it may have came in after I sent the packet to you. Hold on just a second.
Yeah, I definitely didn't after. It was right before I sent in the silt fence pictures. Again, I'm sorry, I apologize. We just checked again today and then we were able to get the two signatures. One of the neighbors rents out the home, so we had to find the owner of the home and kind of chase him down.
Here you go, Madam Chair.
All right, so it's 2436 is one of them, and the other is 2428. So those are the two next door neighbors, but not the rear neighbors.
Right, those were the two that we haven't been able to contact.
Okay. All right, thank you for your input. I guess the discussions with the board. Do we have a direction here?
I don't know if my colleagues agree with my concerns or not.
I do.
I think I lost Mr. Melnick.
Oh, he's there.
Okay. Well, why don't we try a motion and see what happens?
Madam Chair, I move that we defer this item to the September 30th BZA meeting for the purpose of allowing the applicant to propose additional water retention elements to the proposal, as well as additional time to reach out to the rear neighbors regarding water runoff.
Is there a second?
I'll second, but also just include that it's V11547-20-UP1.
Thank you. So we have a motion to defer to the September BZA for a couple of reasons. Certainly getting the background, getting information from the rear neighbors, it would help clarify things a great deal, but also figuring out what impacts the water would have, I think, is important. If there's no further discussion, I'll call the roll.
Madam Chair?
Mr. Owen.
Yes, I just want to add that it seems like the applicants are working in good faith on this issue, and so this isn't meant to be punitive. This is a normal kind of concern that we have on a lot of applications that come before the BZA, and just given the topology of the site, it's important, I think, for us to be cautious. So I think it's appreciated the applicant's work so far, and I know it's frustrating to have a further delay, but we appreciate the applicants making sure that we can get this done right.
Thank you. I will call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick?
Aye.
Ms. Clark?
Aye.
Chair votes aye. The motion to defer to the September 30th BZA passes 5-0. To the applicants, we hope we've been clear as to what our concerns are and what we hope you can share with us when you come back.
Thank you so much for your time. I appreciate it.
Thank you.
Thank you.
Thank you. Mr. Rissy, would you call the next item, please?
The next item is case number V-11548-20-UP-1. It is a use permit request by Nikki and Andy Jones, the owners, to permit a right side setback of 7.9 feet to the wall instead of 8 feet as required from the right side property line, and to permit a left side setback of 8.1 feet to the wall instead of 10 feet as required from the left side property line, and to permit an aggregate of 16 feet instead of 18 feet as required in the R6 zoning district regarding a rear two-story addition in the R6 zoning district on the premise known as 5719 4th Street North. Staff recommends the board adopt the attached proposed resolution granting use permit request with conditions, and I'd ask you to please note that there is supplemental material for this case that came in after the application packet was assembled and printed.
Thank you. Mr. Rizzi, are there any speakers on this item besides the applicants?
Madam Chair, the only other speaker could be the applicant's agent, Mr. Oliver.
All right. Is there anyone else here that wishes to speak on this item? Okay. No one else. Thank you. Any questions for staff? All right. Let's hear from the applicant. Nikki and Andy Jones, are you with us?
Yes, hi, this is Andy Jones. Pretty straightforward, looking to do a 10-foot addition onto our house. We're actually sticking with the same kind of footprint, if you will, sort of extending the existing walls of the house out back by 10 feet. The way it was built, it is at those dimensions that I think Stephen laid out earlier. We did talk to our neighbors on both sides, in front of us and behind us, got their sign off and agreement with the project. So thanks for your time and consideration. Happy to answer any questions.
All right. Give me any questions for the applicant? 5723, 57. Hey, Mr. Owen.
I'm prepared to make a motion.
Yeah. Thank you for getting these sign-offs. That certainly makes it easier for us to move forward. Mr. Owen.
I move that the Board of Zoning Appeals approve the attached proposed resolution approving use permit V-11548-20-UP-1 with an additional condition number 3 with a 3-year time limit as we have been doing on the other items.
I'll second.
Ms. Clark seconds the motion. Any further discussion? I will call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick?
Aye.
Ms. Clark?
Aye.
Chair votes aye. The motion passes 5-0. The use permit is granted. All right.
Thank you very much.
You're ready to go. All right. Take care. Bye-bye. Mr. Rissy, next item, please.
The next case is V-11549-20-UP-1 is a use permit request by Batista Hazandai by Bebahani, the owner, to permit after-the-fact approval for a street setback of 8 feet to the wall, 6.5 feet to the eave, to an accessory structure, shed instead of 25 feet to the wall, 21 feet to the eave, as required from 24th Street South, and to permit a right setback of 5 feet to an accessory structure, including a gazebo and deck, 4.7 feet to the gazebo's eave from the right side property line, instead of 8 feet to the gazebo, 5 feet to the deck and gazebo's eave, as required from the side property line, regarding previously constructed shed and gazebo in the R10 zoning district on the premise known as 2345 South Ode Street. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions, and I'd like to please note that there is supplemental material for this case that came in after the application packet was assembled and printed. And additionally, we do have additional speakers who have signed up to speak on this item.
Yeah, let's see if we can corral them. You have a list of speakers. Can you show that list? Mr. Rizzi, do you have a list of speakers? Okay.
Yes, Madam Chair.
All right. Is there anyone else here wishing to speak on this item? Okay, so that's our speaker list. All right, let's start with questions to staff. Ms. Freshman.
Was this a result of a complaint?
I believe that is the case, Ms. Freshman.
So there's an enforcement action pending?
Yes, ma'am.
All right. Any other questions for staff?
Madam Chair.
I sort of wonder how they got to a recommendation for approval.
Staff recommends approval or denial based on the comparable structures we can find in the surrounding area, Ms. Freshman.
Madam
It's
Chair.
the only way we can stay objective.
All right. Mr. Owen.
Yes. The parcel address is on Ode Street, and the application is requesting relief from the right side property line. However, the applicant's materials from time to time refer to the location of the new structure as being in the backyard or rear yard. Which side of this particular property is the front of the parcel for zoning purposes?
Yes. Again, on a corner lot, the shorter frontage is considered the front for zoning. So this is the front, this is the rear, and these are both sides.
So the front is on which street?
Yeah.
Now I need to look at the plat because I think
Yeah, it looks different.
Yep. I think our front is
On 24th Street?
this side. Let me pull it up.
In reading the plat, it seems to me that it's 100 feet on 24th and 113 feet on Ode, which would suggest that 24th is the front. But I don't know if staff agrees with that.
Yes. Staff agrees.
Oh,
24th
okay.
Street.
All right, 24th is the front of the parcel. Okay. Additional question, Madam Chair.
Go
There
ahead.
is a fence between the new shed and gazebo and 24th Street that both the applicant and the neighbors talk about the effect of the fence on these structures for purposes of making their case. It seemed to me when I visited that the ground on which the fence sits is a foot or two higher than the sidewalk in front of the fence. Does staff know what is the height of that fence?
Staff can't verify the height of the fence. I haven't been out to measure it, but I will say that there was a fence permit approved for a 6-foot tall fence.
I see. What is the zoning height limit in the front of a parcel in the location that the fence is?
In the location of the fence, if that is considered a front, the height limit should be 4 feet, 25 feet back from the street.
Okay.
So, could you repeat that, Mr. Rissy? Now that we know what the front is, I'm reading the subject section, right? So, we're asking for a front yard setback of 8 feet.
Yes. Well, again, it's not a front setback. We don't have front setbacks. We only have street setbacks. The setback is always 25 feet from the street,
Okay.
regardless of whether it is a front or side street.
Okay.
But for fences, there's a different height limit for fronts and sides, right?
Well, yes. On a front, you have to be 25 feet back from the street. On a side, you have to be more than 3 feet back from the street.
Okay.
So that suggests that the fence is too close to the street?
That suggests that when they got approval for the fence permit, the person reviewing the application thought that Ode Street was the front.
I stopped.
And in general, how do we determine the height of a fence? Is it measured from the ground underneath the fence, or is it measured from the average height of the property, or from some other point?
It is measured from the ground under the fence.
So if a person builds a soil berm, they can build an allowable fence height on top of the berm if they want.
Correct. Or if you have a sloping topography, you would have to slope your fence with the topography.
Okay. Well, that's unfortunate.
So, Mr. Owen, I'm sorry, Mr. Rissy, another clarification. So were these structures built without a building permit?
I believe the applicant's agent would actually like to speak to that, but my understanding is that neither structure required a building permit.
Yeah, in the application, the applicant refers to wanting to build according to the requirements of a building permit. If I'm reading I think it was in the justification. So no, right now for what is there, a building permit would not be required.
That is my understanding.
All right. And the other, one other question, with regard to the shed, the staff report seemed to say that the applicant informed zoning staff that the shed is not attached to a permanent foundation. Has there been any independent verification of that?
I'm not aware of any, Madam Chair.
Okay.
Mr. Rissy?
Yes.
Go ahead, Mr. Owen.
Madam
Go
Chair.
ahead. Yeah, go ahead, Mr. Owen.
So if not asking in this case in particular, but just in general, if I'm neighbors with someone and they build like a 12-foot tall fence, and I am concerned about that and I complain, and they say, oh, well, it was approved by the county, and I go to the county and find, yes, indeed, this was erroneously approved by the county. What's my recourse as a neighbor to get it fixed, to get the situation fixed?
It depends on the duration of time that the permit has been approved. We've had this situation come up before where if it's within a appealable time period, you can appeal that building permit and staff can rescind it. However, once it passes 60 days, it is a thing decided and staff doesn't have the ability to rescind that approval.
Okay, thank you.
Okay, any other questions for staff? All right, let's hear from the applicant. That would be Mr. Bahabani.
Actually, Madam Chair, it's Arian Hosseini. Good evening, dear board members, county staff, and neighbors. My name is Arian Hosseini. I will be speaking on behalf of Batisa Behbahani for subject property known as 2345 South O Street. My mother, Batisa Behbahani, she has a language barrier which prohibits her from communicating directly with the board.
Okay, welcome.
Thank you.
Madam Chair,
Mr.
do
Owen?
we have a written delegation to this agent?
I don't think we do. There's nothing in the application that makes this official.
Did Mr. Rissy receive an additional letter from the applicant delegating an agent for tonight's meeting?
I don't have any additional letters from the applicant.
Okay.
All right, so where does that leave us? Technically, the applicant is not here.
Well, Madam Chair, I actually emailed Mr. Rissy prior to this meeting stating that I will be representing my mother.
Mr. Rissy?
That is true, Madam Chair. I have an email from the agent stating that he would be speaking on behalf of the applicant.
Okay. Is that satisfactory?
Madam Chair, the agent is actually the individual who has submitted the application, and we've been working with him the entire time. I do not think there is an issue in this instance.
Okay.
But if the board disagrees, it is.
I don't think we could issue an approval without getting a delegation. I don't know if that's the direction we're heading anyway, but we might as well proceed.
If it helps, I do hold a durable power of attorney from my mother. I could submit that to the county, but she does not communicate well in English. English is neither her first language or my first language. So
there's no problem with having an agent. We just have to have it in writing that you're authorized to speak for her. That's the problem.
She gives the authorization, and so that's.
I'm sorry.
Go ahead, Mr. Owen.
We've had a situation in the past where a family member has come to our meeting and said they were speaking on behalf of the parent, and it turns out they were not authorized, and the parent did not know that the child had come to speak for them. So that's why we need to have something in writing to show that the agent is in fact authorized.
If it's something that is in writing or it has to be notarized, I can produce that at the given time. But if it's satisfactory to the board, I could call her right now and you could ask authorization on my behalf. Or
I think we're gonna have to hold off on that because I think we do need it in writing. So I think the best thing to do right now is go ahead and, you can proceed with your testimony, and then we'll decide where we go from there.
Alrighty. So, Madam Chair, I don't have any additional information to add at this time. I am present to answer any questions from the board. That is it.
So you have no information about the circumstances of this being built?
Well, no, I was the one who built the structures.
Okay. And evidently, it appears that you did not have all the permissions that you needed. Do you agree with that?
Not really, Madam Chair. With all due respect, this is the diagram that I was provided with from Mr. Rissy, indicating Oat Street as the front. I don't know if you could see his handwriting clearly, but this was the diagram, and the neighbors are present. You could ask them which side is the front. Truly, the front door, it faces Oat Street, and that's what I always consider the front. And when the question of a fence was presented, I have a diagram from section 3.2.6A, 3A and E, which kind of shows how a fence can be built on a corner lot. I don't know if this is something Mr. Rissy can pull up so we can all view, but it shows that all proper setbacks have been met.
You're talking about the fence.
Yes,
So,
the fence. Well, yes, we are seeking leniency from the board as in respect to the relief from the setbacks or relevant setback laws. Yes.
So, but you realize that you have built something that needed approval.
Yes, yes. I was educated from Mr. Rissy's behalf. Prior to that, I had no idea regarding zoning laws.
Okay, until the county contacted you.
Yes, until there was a zoning enforcement
Okay.
officer. Yeah.
Okay. All right. All right. Any questions for the applicant or the speaker? All right. Then, Mr. Rissy, let's start with the neighbors or the speakers. I assume they're the neighbors. Mr. Hall?
Yes, hello.
Do you have your, yes, there you are.
Yes, ma'am.
Thank you.
I am ready to go.
Okay.
Okay. Hello, board members. I hope you're doing well and staying safe. My name is Dennis Hoke. I live across the street from the subject property at 2344 South Oat Street. My wife and I have serious concerns about agenda item 12, this item, and the use of the property. I have 4 requests for the board. First, I ask you to review my comment letter in which I provide specific zoning ordinance citations and the relevant facts. Second, I ask you to review the stop work and permit history for the property since 2018. Third, I ask you to please keep in mind that Oak Ridge Elementary School is directly across the street. And fourth, I urge you to decline the after the fact use permit and investigate the other ordinance violations identified in my letter. The facts do not support the findings required for the board to approve a use permit. First and most important is safety. The shed and tall white privacy fence block sight lines around the school, which is bad for situational awareness and public safety. The safety of our students, parents, teachers, and school staff is paramount. Second, the shed, gazebo deck, and fence are completely inconsistent with the neighborhood. The differences are quantifiable and unambiguous. The staff analysis cannot justify new violations by looking for existing violations. Third, this and other activity ignores the zoning ordinance and harms the general welfare. The application would be detrimental to safety, would overcrowd the land, and would be an inappropriate use of the land. In addition, there are other violations not addressed by the application or staff report. These are distances between structures, the privacy fence, and the Airbnb operation at the property. The Airbnb operation is not clearly incidental and subordinate to the principal use. All these issues are addressed in my comment letter. Thank you for the opportunity this evening.
Thank you. You should know that we received a large number of correspondence today that we are all trying to read through as we can. So I appreciate your concise summary of your concerns.
Madam Chair?
Yes, Mr. Irwin.
That reminds me to ask staff if the applicant's presumed agent has also been provided copies of those letters.
No, Mr. Owen. Those only recently come in, and we've only shared them with you this evening.
Okay. Well, in the interest of fairness, could we send an email to the applicant's presumed agent with copies of that as well?
Sure thing.
So we're all dealing with the same record.
Thank you, Mr. Rissy. The next speaker is Allegra Sensenig.
Correct.
Thank you. You want to? Do you have video that you want to turn
I have
on?
video. I have video, and I've turned it on, so I don't know if it will come on or not. But if you can hear, there I am. Okay.
There you are.
Okay. Good evening. My name is Allegra Sensenig. My husband and I own and occupy 2337 South Ode Street. We speak in support of the written submissions by Mr. Hoke and later Mr. Koresh, and join in the statements of opposition submitted by multiple neighbors. 2345 South Ode Street has a recent history of permit violations, including a stop work order in 2019 regarding residential work when it was halted. In addition to matters being considered this evening, there are zoning violations not addressed by the owner application or staff report. These include distances among accessory and primary structures, overcrowding of the lot, the privacy fence, and the operation of an Airbnb at the property. The shed, gazebo, deck, and fence are inconsistent with neighboring residences and accessory structures. We agree with other statements provided you in opposition to this request. We ask for the following: a review of the history of neglect to obtain permits and a review of overcrowding of structures presently on the lot. We would like to hear from the owner of 1409 24th Street South, the property immediately adjacent to the encroachment by the gazebo and the deck. We would like to hear from Oak Ridge Elementary School, directly across the street, as the shed and privacy fence interfere with visibility and safety. We ask for an investigation of the Airbnb operation advertising 7 bedrooms, a use clearly not incidental and subordinate to the principal use. We request the signatures produced by the applicant as part of this application tonight be disregarded, and that the surrounding community, to include Oak Ridge Elementary, be resurveyed with the additional information that the property is operating as an Airbnb. We refer you to the written comments we have submitted for consideration. We urge you to decline the after-the-fact use permit and further investigate the other violations identified by neighboring residents. Thank you.
Thank you, Ms. Sensenig. Next speaker is Louis Koresh.
Yes, my name is, good evening. My name is Louis Karish. I live at 2334 South Ode Street with my wife and my daughter. We have resided here for 19 years. I share the views of opposition expressed by my neighbors. And in addition to my written comments that I submitted, I offer the following additional thoughts for the board's consideration. Number one, that the structures are not compatible with others in the neighborhood. The structures at the subject property are excessively large and highly visible from all directions. Other such structures in the neighborhood that might be similar in size are principally garages that are at the end of driveways in the back, or small storage sheds at the back of property that are mostly hidden from view at the street. Number two, that the proximity of Oak Ridge Elementary School raises safety concerns with regard to children attending the school and children in the neighborhood. Number three, that the stated justification for the structures, that the only use of the yard is a shed because of noise, and that the storage is needed because this is a small house is not supportable and it's not convincing. And number 4, that because of this stated justification is relevant in this case for the board to consider that the clear primary use of this house is as an accessory homestay facility with a large number of rooms rented rather than as a single family home. And that is what is creating the desire for these oversized structures that are incompatible with and injurious to the neighborhood and the families that live here. So for these reasons and others stated by the residents in our written statements, I request the board deny this permit. Thank you.
Thank you, Mr. Karash. Next speaker, I lost the list. Mr. Rizzi. Aaron Anderson. Is Miss Anderson here?
Yes. Yes.
All right.
This is Erin Anderson. It took me a while to get unmuted.
Oh, okay. All right. And do you have video too?
No, actually, I do not have video.
That's fine.
I'm sort of a rushed addition to this event, so I have no prepared. Corroborate the previous comments that are made. I want to mention I'm one of the houses on Oak Street, and what concerns me is that my garage was used as a comparable to permit this residence to build their added building, which I think is a pathetic comparison. My garage is architecturally integrity with the rest of my house and the neighborhood, and it is off the street. It is barely visible. So to use my house as a comparison to permit their buildings, I think is totally inappropriate. Furthermore, this house is not a residence, despite what people might say. It's not even an Airbnb. It's a hotel. It's a full-fledged hotel, and we have to tolerate day, noon, and night more than 5 to 6 cars on a regular basis surrounding this house. Even during this COVID crisis, that did not discourage activity at this house to be operated as a hotel. Furthermore, one time when I was walking by the front door of this house, which does face Oak Street, I just happened to look through, and instead of seeing a proper foyer in a home, I saw a commercial-sized washing machine where and I'm trying to figure out why would, as soon as you walk into a home, a residence, the first thing you see is a chrome silver colored commercial-sized washing machine, unless of course you're running a full-fledged hotel with laundry service. I could go on, but I think that you get the point.
Miss Anderson, thank you. What is your street address?
Oh yes, my street address is 2333 South Oak Street.
2333?
Yes.
Thank you. I think I believe concludes the speakers. Board members, any questions for the applicant or presumed agent or staff at this point? Okay. Then looks like Miss Freshman.
I find this really disturbing. I think if we had an application like this to before the fact, it'd be kicked to the curb. And I'm never terribly sympathetic with after the fact applications, but sometimes there's a rationale. I don't see one here. So I cannot support anything about this project at all. I think that it should be denied.
Any other comments from my colleagues?
Madam Chair.
Mr. Owen?
We're required to find that in order to approve a proposal that it's compatible with the development of the surrounding neighborhood because the overall footprint size and placement are similar to the structures on the property surrounding the subject property, among other things. And I don't believe that the proper interpretation of those words is if anywhere in the whole neighborhood, any parcel has any structure whose dimensions are, worse, I'm putting that in air quotes, than the proposal, then that is met. I don't think that's the way to evaluate that standard. I think you have to have some relationship to the literally surrounding properties. Now, that's a little bit of a judgment call. Is the surrounding property only the abutting properties? Is it the properties you could see? Is it the properties that I would say maybe it makes up the character of the parcel in question because it's on the way to and from it, But I don't think that the examples in the staff report of more excessive size or more narrow placement of other structures are, with one exception, close enough to the subject property to be considered surrounding. And as the speakers have pointed out, they're also not similar in character to the proposals here. So with the earlier application, where we had a porch tacked onto the porch, and the nearest closer example was 1.5 blocks away, but there were some abutting properties that were, sort of similar. That was a tough call for me. But this is not a tough call. This is, to me, an easy call. I think that this is exactly the kind of situation that the language in the county board's test was designed to, not allow to be approved. And so I don't think that either of these structures can be approved. And it's disappointing that the fence was erroneously approved and it may be too late to change it, because I think the county's laws and the county's policies are contrary to what is being built here.
Any other comments?
Madam Chair, am I allowed to comment, or is this just solely for the staff or the board members?
Well, at this point, at the discussions with the board, I mean, do you have more information that we don't have?
Regarding many of the neighbors expressed their concerns regarding Airbnb. I don't see the relevance. I'm not sure. I thought I'm seeking relief from setback laws, but also as the Airbnb, I do have an accessory homestay permit issued by Arlington County, which has its own right. And regarding the deck structure, well, the deck is in 2 sections, and one part of it is uncovered, and then the other part of it is covered. The covered part is considered a gazebo for the purposes of this hearing. And based on the diagrams that I have, if I were to remove the roof on top of the deck, I would be allowed a permitted encroachment based on section 3.2.6A.3A, which allows me to project 4 feet into the setback if that's being classified as a deck. I wonder if that holds true, or would I forfeit the right of permitted encroachment?
So we have to act on what's before us. And right now what's before us is a gazebo and a deck. We are not, we're weighing in only on the zoning matters. We are not giving an opinion on an Airbnb or whether that's proper or improper. Strictly, our discussion is strictly, our action is strictly on the zoning and the conditions that exist right now. And that's all that we can look at.
And Madam Chair, I'll just amplify your point that as far as I'm concerned, the Airbnb question is not relevant to the analysis that I'm making tonight.
That's what I was thinking. And it seems like I have a lot of concerned neighbors, which they haven't reached out to me in the past, and I haven't received any sort of feedback. And this is the first time that I'm hearing about this. So if they're expressing these big problems, it's the first time that I'm hearing about it. And I'm a person that's very easily approachable. I'm always in the front yard. I'm always saying hello to these people, and never once did I hear anything regarding this.
Madam Chair,
Mr. Owen.
Are we now at the point where the discussion is back with
Yeah,
the board?
I think we need to move forward on this one. Mr. Owen.
Yeah, I mean, I had some other questions prepared, as you've heard earlier in the hearing. Those who are listening, you know, we often have a lot of questions about, did you talk to this adjacent neighbor and did you talk to that adjacent neighbor? I certainly agree that in an ordinary case, the views at 1409 24th and of the elementary school would be relevant too. But this is just so far away, in my opinion, from being an approvable project that I don't think there's any point in discussing the neighbor outreach to those neighbors. It seems pretty clear cut to me. So I know Mr. Melnick and Ms. Clark have not spoken, so I don't know if there's a majority, and Madam Chair, you've not spoken, so I don't know if there's a majority view to make a motion, but those are my views.
I would support a motion to deny.
I would agree with that also.
Mr. Melnick, do you want to? You can wait for the motion if you wish.
Yeah, I'd support a motion to deny also.
Madam Chair,
we've got Ms. Freshman.
Go ahead, Mr. Owen. That's fine.
We have to work on the findings.
Yeah, I move that the Board of Zoning Appeals approve the attached proposed resolution reframed as a motion denying the use permit V-11549-20-UP-1 with changes to 3 of the whereas clauses, deleting the whereas clause, the 3rd and the 4th whereas clause, so deleting the finding that the proposal will not be detrimental to the public welfare, deleting the finding that the proposal will not conflict with the purposes of the master plan, and modifying the final whereas clause to read, and I mean just inserting the word not in 3 places. So it would say, whereas the BZA has determined that the modification is not compatible with the development in the surrounding neighborhood and the structure's overall footprint size and placement are not similar to comparable structures and other properties surrounding the lot in question, and the proposal would not help preserve the natural landform, historic features, and significant trees. And then in the resolve clause, now therefore be it resolved that the BZA hereby denies rather than approves the special use permit case number V-11549-20-UP-1 period, and delete all of the material thereafter.
Mr. Rizzi, do you have that?
Second.
Yes,
Seconded. Any further discussion? I will call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick?
Aye.
Ms. Clark?
Aye.
Chair votes aye. The motion to deny is adopted 5-0.
Thank you, Board, for taking the time tonight to review the case. I appreciate it.
Thank you for coming. All right, Mr. Rizzi, I believe this is our last case.
Yes, Madam Chair, and that is case number V-11550-20-UP-1. It is a use permit request by Joseph Lynch and Susan Dunlap, the owners, to permit a left side setback of 5.5 feet to the wall of the sunroom, 4.7 feet to the eave from the side property line instead of 8 feet to the wall, 5 feet to the eave as required regarding a 1-story rear sunroom addition in the R6 zoning district on the premise known as 2527 18th Street North. Staff recommends the board adopt the attached proposed resolution granting the use permit request with conditions. And I would like to please note that there is supplemental material for this case that came in after the application packet was assembled and printed.
And that supplemental material is additional, is a neighborhood petition in support of the application.
Correct, Madam Chair.
Do we have speakers for this item?
Madam Chair, we don't have any additional speakers, so the only speakers would be the applicant, Joseph Lynch, and his agent, Bob Braddock.
All right, is there anyone else here tonight that wishes to speak on this item? Sounds like no, so welcome applicant. Who wants to speak?
This is Bill Lynch.
I'm sorry, Mr. Lynch, let me ask one, I'm sorry, I forgot to ask. Are there any questions for staff? All right, just wanted to make sure. Thank you, Mr. Lynch.
Well, thank you, and I appreciate the time that the board has put in on this and staff. I think the application speaks for itself. It's been a long night for everyone, so I'll answer any questions that you have, but I don't have anything else to offer.
All right, thank you, Mr. Lynch. And
Madam Chair, I know it's not relevant, but there's an impressive guitar collection behind the applicant's shoulder.
If only my playing were just as impressive.
So unfortunately, my controls sort of sometimes, when the controls go away, I lose the names of the person that you have. It's Mr. Braddock.
I'm not sure. Bob,
Yes, I'm the architect.
Okay.
I'm just here in case there's any technical questions.
All right, thank you. Any questions of the applicant? Okay, discussions with the board.
Madam Chair.
Mr.
I
Owen?
just would thank the applicant for making sure to get the neighbor feedback. To me, it was the critical missing element for this project.
It's much appreciated. Without it, we're sometimes in the dark. Do we want to move forward, Ms. Freshman?
Motion?
Yes, please.
I move the Board of Zoning Appeals approve the attached proposed resolution approving the use permit V-11550-20-UP1 subject to the conditions listed and including the third condition for a 3-year term limit.
That's right. We have a 3. We'll add that one. Is there a second?
I'll second. There's Paul Melnick.
Mr. Melnick, thank you. Any further discussion? I will call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick?
Aye.
Ms. Clark?
Aye.
Chair votes aye. The motion passes 5-0, granting the use permit with conditions. All right. What class were you, March or April?
I think we actually met in February.
February, wow.
Yeah.
Okay, well, thank you very much. Your use permit is.
Thank you very much. I appreciate the
All
approval.
right, thank you. We have minutes. Ms. Freshman?
I move approval of the minutes from Wednesday, July 29th, 2020.
There a second?
I'll second. Ms. Paul.
All right, I'll call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick? Did you say aye? Mr.
Oh, I'm
Melnick?
sorry. Yes, aye.
Ms. Clark?
Aye.
Chair votes aye. The minutes are approved 5-0. I have one more item before we adjourn, and that is a matter that Mr. Owen wants to explain.
Yes, I had a discussion with Stephen and Arlova yesterday about trying to, and following up on conversations we had last year or the year before, about trying to revise our financial disclosure form, which a lot of people fill out the wrong way. And so Arlova kindly agreed to let me propose a new draft. And my question is, I have a draft ready, and do you guys, I know Mr. Melnick in particular often focuses in on this particular document. Would it be the board's preference that we talk, that I share it with the board members first, or would the preference be that I share it with staff first?
Mr. Rissy has his hand up. Oh, you're muted. You're also
Separate
muted.
item, Madam Chair.
Okay. Something yet to, did I overlook calling on you, or is it something else you want to bring up?
Something else.
Okay. All right. You'll wait your turn then. Okay. So the question is, do we want Peter to give his suggested draft to staff for their review before we circulate it among ourselves, or do we want to see it first?
I don't feel that I'm knowledgeable enough to probably make any cogent comments. So I personally, I'll look at it if that's the decision. But I would defer to the professionals. And I'm getting a lot of feedback noise. I can barely hear you guys.
Okay.
Yeah, I'm in agreement that, staff ought to, just give their initial thoughts about it. I don't know if Peter is thinking about taking his form and do like a track changes so that we could see the markup of the county. Maybe that'd be helpful. But I think that'd be good just to get the version that staff's already seen.
Okay, I'll work with staff first then, and we'll come back to you so you can see it. It's pretty different.
Yeah, the track changes might not work on a form, I guess.
But
maybe,
I think
maybe a narrative of some sort.
Yeah, I think we can explain it in a way that will make sense, though.
All right, so we'll do that. Thank you, Mr. Owen, for volunteering.
Yes, and Madam Chair.
Yes.
Maybe something also helpful. I don't know if it'd be helpful to make comments on it. Like if there's a particular provision that needs a comment, or if Peter just wants to do that verbally, like when we get it. So, anyway.
Yeah, I think, Mr. Melnick, I think what I may do is I may send it to staff and show you anyway, just so you can be in the loop without asking you for feedback. But the gist of it is that right now the form basically puts that chart out and gives one big discussion and says, put everyone in this chart that you can think of. And the non-professional, pro se applicants often don't think of all the things that they would need to put in, like the beneficiaries of a trust, like the shareholders of a corporation, like the residence address of the non-resident owner. And so basically the revision that I'm proposing is a series of questions that says, are you in this situation, yes or no? Are you in that situation, yes or no? So that as you answer yes, it tells you what information you need to put in. So that's the overall plan. But I'll show it to you so you can see. And then again, after I get comments from staff.
Yeah, it sounds very helpful.
Okay, thank you, Ms. Freshman.
I just want to make a general comment now that we've had 2 virtual meetings. I think on balance, things have gone pretty well. We had a little speaker thing. As you've seen from my email earlier today, getting a whole lot of late minute stuff is much harder to manage than it was when we got it in person and could look at each piece as the case was called. So I think we need to put more of an effort into putting the burden on the applicants, especially these that have been waiting for months and yet somehow had to send in their signatures this afternoon. That's just garbage and cannot be allowed. So I think we need to be a little tougher. And as far as the meetings are concerned, we're now having two this month and 2 in September. Tonight we had 13 items and really only one of them was terribly controversial, and it still took us 3 hours, in part because we have a slow start. So I'd like just to say that from my point of view, after about this time of night, I start to, fade. And if we can keep our agendas, knowing that there are issues of advertisement, to 15 or less, I would like to urge that, even if it means that going forward, we have to meet twice a month. I think that's much more humane. And it gives us more of an opportunity when we have deferrals not to have to, overload any particular agenda, because we have more frequent meetings. And much as I would love to all get together and share cookies, I don't see that happening for the foreseeable future. I mean, seriously, like maybe not even next year. So given all that, if we can establish a pattern of reasonable agendas in terms of the numbers of items, and we haven't even addressed appeals, which can be really painful, then I think that maybe meeting twice a month is the answer to keeping it more manageable. Just wanted to throw that out.
Yeah, Madam Chair. So yes. I'm in full agreement, because I was out of the office all afternoon at meetings. I got back at around 6, and I had to look during the meeting. I had to look at the supplemental materials on my iPhone, and that's like very, very hard, because it's very small. And I agree that we ought to, I don't know what it would be, saying it's strongly discouraged, to submit supplemental materials after such and such a date. Just do something making people realize that it's not appreciated. If it can be helped, and I know sometimes it can.
Well, here's the thing.
Stephen, when are the packets actually printed? Not handed to us, but actually printed. I mean, because that ought to be the cutoff. People can encourage neighbors. I mean, an applicant could stand up and say, I have the 5 signatures of these neighbors' names and addresses, and we could accept that as fact. Or we could say, if you can't make it by the time we print and distribute the packets, then encourage your neighbor to come on the meeting and speak.
Yeah.
It's, from my standpoint, it is a little tricky because, people, even when we were live, could walk up to the podium and hand us a bunch of papers, right? So it was like, you can't, we hold a public hearing to hear from the public. And, so anything that's submitted during the hearing time, we really do need to accept. But I agree, especially today, that it was ridiculous. And I did not read any of the Ode Street stuff. I mean, it was just impossible to get through that.
Well, that's the challenge, though, is that the Ode Street stuff wasn't the applicant submitting it. It was the neighbors who saw the notices in the neighborhood who were submitting stuff at the last minute. Mm-hmm. And so if we're going to let the neighbors submit stuff, at a certain time, I'm not sure it's fair to not let the applicant also do it on the same deadline.
Yeah,
but a lot of them showed up too, and made and that could happen too.
Yeah, it almost seems like a sabotage situation sometimes. Like at the last minute, there's this deluge of opposition, and the poor applicants, like I just had no clue. And we've seen that happen before.
It's just that this particular applicant wasn't sympathetic.
Yeah, that's true.
Yeah, but I think the one on in Inta's neighborhood, to me, was a little more frustrating, because it seemed like on Monday they finally heard that they really needed to get their butt in gear. Mm-hmm. And I feel like Monday was not the right time for them to get that message. Mm-hmm. And I don't know what we can do to give them that message, to give people like that a message in more time, to give them more time to do it. And I know, Mr. Rissy, you already have as part of your plan to admonish people from time to time, but I don't understand on that project in particular why they suddenly only got into gear on Monday. What what can we say to them at an earlier time that might have the same effect? And maybe you have some suggestions.
Mr. Owen, if I could just ask which case you're specifically referencing?
The one in Claremont on Culpeper Street, the drainage issue that we deferred.
2432 South Culpeper.
I'll admit that one of the cases that actually sent me material today wasn't an issue of them not submitting it early enough. It was actually a clerical issue where they submitted it to us in June when it was supposed to be heard the second time. They were originally scheduled for April. When that got canceled, they were put on an agenda for June. And we took it in with material before we canceled that meeting, and I just didn't have it in the new folder that we set up from April for August. So, I mean, there's a lot of different ways things like this get complicated quickly. I will agree that a lot of the comments that you guys received tonight, probably 90% or more, were not from the applicants, but were from the neighbors specific to the Ode Street project. It seems like they talked to each other over the weekend and together and decided they all wanted to be have their thoughts heard, and that's not uncommon. And I do think it's important to give everyone as much opportunity to get their feedback to you as we can. And yes, it's not convenient. I would love to stop it. I will say that throughout the process, we email the applicants probably 3 or 4 times. And I think in just about every email that I send, I mention that if you haven't gotten your neighbor support to us, get it to us now. And honestly, it's sometimes questions from the board members that are what motivate the applicants most.
So in the final round of you asking, you're specifically saying the board is asking why you don't have signatures. Do you change the language in that final appeal?
There's different emails that I send. There's a general email that I send. I'll skip the earlier ones. The final general email pre-COVID, the final general email that I sent was when the staff reports have been drafted, but before we print them. And at that time, I say, review it, make sure we have all the names right. And if you see we're missing anything, like neighbor support, please get it to us. Now, traditionally, that was the last communication I had. Now there's another one telling them how to join the meeting, but that's not important. But after that, once the applications are reviewed and questions are transmitted to me, I will email only those applicants who have questions and say, after reviewing your application, one of the board members has a question for you regarding your case. You do not need to reply to me with an answer. This is just for you in case it comes up. Here is the question.
Okay.
Do they still get a letter from us that we drafted years ago expressing the board's strong need?
Yes, that is still a part of the application package that is online. It's part of the package that they have to submit to us. It is pages 9 through 11 of the packet, actually. So it is still there.
It obviously doesn't make much of an impact on some people.
There will be a slight change coming. The end of the year, we are going to an online permitting system. And the online permitting system obviously has a different setup than the current application. We also, well, we're here. Okay. So they are going to have to, for the new system, they're going to have to check a box that essentially says that they have read your letter. So it's one of the enhancements we're trying to have with the new online system.
So we can find them.
Again,
maybe INTA has to send an email. Could the chair send a reminder?
I don't know you want to go that way.
No, I just find it that year after year, there doesn't seem to be a way to get people to do the right thing. Well, or to even comprehend that it can affect their project. At the very least, it can defer it if it doesn't kick it out. And that doesn't seem to get through.
I think that's the thing that's difficult for Mr. Rissy to say on his own. You know, we can say, if you don't do this, you might be deferred. But I think as staff, it's not, without us telling him to do it, it's harder for Mr. Rissy to predict what we will do in a given case. So I think when, I don't know if it's possible, but maybe if we authorize Mr. Rissy to send another email to the people on the August and September agenda to say the BZA has had to defer several items that we're waiting since the winter because not all the neighbor feedback was in. And the board wishes to avoid further deferrals, and therefore please be sure that you have done everything possible to get feedback from all adjacent neighbors per the board's, instruction letter.
Yeah,
But
it's
maybe
in your best interest.
right. But I think it might be that Mr. Rissy's admonitions are appropriately general, and they're buried maybe in other information he's giving them. Whereas when they get the question that says, here's the specific address points that you're missing, what's going on? That seems to be what wakes them up. And when it's coming from a board member, the implication is, this might affect the decision.
But by definition, that's too late for it to be timely in any practical sense.
Yeah. Yep. So maybe a message from the chair through Stephen to the next batch of applicants, could be phrased that might boost the output a little bit in the short run until we get to the permits plus system that gives them that, boost the other way.
Stephen, you got your hand up?
Yeah, unfortunately, a couple things. First, it may be too late to reach the next batch of applicants as we are meeting again next week, and those packets are being printed tomorrow. I told everyone they needed to get any edits to me by the end of the day today. So it may not be available for August 19th. Earlier, I raised my hand because I did want to bring up the upcoming meetings. We have gotten a bit off of our calendar for the year, and I wasn't sure if the BZA wanted to fix that and fix some upcoming dates that we know we are having meetings.
You mean, are you saying adopt a new calendar, a new schedule?
Or just modify the existing one?
Well, we already have September, right? And October 1.
Right. We have two in September, and then October, November, December right now. Are you seeing a need for more?
No, I'm just saying that we've discussed them, but they aren't officially part of our calendar.
I'm prepared to make a motion.
Make that motion, yes.
I move that the Board of Zoning Appeals ratify the meeting date of July 29th, August 12th, August 19th, September 16th, and September 30th.
What about October?
Well, the rest is already in our schedule.
In addition to the rest of the calendar previously adopted.
So it's really amend our July and August and September schedule.
Yes.
Okay, I'll second.
All right. Roll call. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick?
Aye.
Ms. Clark?
Aye.
Chair votes aye to amend our meeting schedule for the months of July, August, and September.
Okay.
Thank you, Stephen. I think we were meaning to do that, but we're kind of have a little more flexibility right now with the continuity of operations ordinance to punt things. So going back to the other matter, as far as a message from me, what do you think?
If you would like to put together an email and send it to me that you would like me to send to the applicants for any of the future meetings, I am happy to do so.
I suggest it not be close to the time when when everything's printed.
Yeah, we have to figure out what the best timing is for
Yeah.
that. So that there's time to respond.
Mr. Rissy, how burdensome would it be for staff to, at the appropriate time, list for the applicants what's missing? The address points that are missing?
I mean, it can be done, but the issue is I don't think staff can tell applicants that they are missing any neighbor feedback. That's my personal opinion. Staff doesn't have a legal reason, a legal requirement for anyone to submit anything other than the applicant.
Yeah.
And that's my...
I agree that you can't be the one that says you have to give this, but I'm wondering if you can be the ones who observe which of the abutting notified properties are not, don't correspond to a signature that we got back.
I mean, maybe. I think it's getting pretty close to feeling like an applicant, feeling for an applicant like staff is directing them to do that, which I think is inappropriate.
Yeah, so what I'm envisioning is a communication from the chair that says, here's what we expect of you. And then in her letter, which you as the secretary are helping her as a clerical thing, you know, she has a blank and says, it appears that you are missing these 4 things, right? And then her signature goes at the bottom. So it might not, the applicant might not even realize that staff helped the chair identify which 4 were missing. That's the sort of thing I'm envisioning.
That would certainly make me more comfortable than it being in my name.
But I think it does seem to be helpful to them to see, like, literally, we noticed your left side neighbor, you know, 2121 is missing, you know, and when that fact is before them, that seems to be helpful.
Judy?
There was a time a few years back, I don't remember exactly when the tax map that was in the staff report shaded those properties for which we had comment. And so you could very easily tell what was missing. I'm sure that that's way too much trouble, but that's essentially what we do when we read our reports and we look at the input and we make a little check mark on our own little map and then make a big circle from the ones that are missing, or however we do it. And that was very helpful. And it would also, depending on when it was done in the process, would tell everybody involved, including the applicants, where the holes are. So I guess we're trying to figure out a way to do something like that. The advantage there was it was very obvious and graphic and didn't require a lot of explanation. But I don't think we want, you know, the problem is coming up with any kind of an additional effort that is going to put more burden on the staff. But at the same time, try in their regular process, if they contact the people 3 times, then maybe the second of the third. The second one is the one where, you know, we juice it a little bit from the board. Because maybe they get the letter, and maybe when it's online, they're even going to check that they read it. That doesn't guarantee we're going to get any better response than we get now. It just guarantees that they read it.
Stephen, in the normal course of events, when does the ideal applicant submit the neighborhood information?
I mean, ideally, they submit it to us when they submit their application. Short of that, we encourage everyone to get it to us 1 month after they make their application, because that's when we start to write the staff reports, and we mention the neighbor outreach as a section of the staff report.
And that's when you write that And when do you start to write it? I mean, what's the last moment that an applicant can tell you, feed you more signatures that actually make the staff report?
Minutes before I print the packet.
Okay, so all right. So the goal is, to notify the applicant in sufficient time that you get the feedback at a reasonable time to get into the report before it's but no later than before it's printed.
How about like a week before? Just give these people a week to try to solve the problem. Is that feasible? Yeah, like a week before you print the package. Steve.
I'm trying to think of how that would work. I mean,
further. Sorry, go ahead.
No. Go ahead.
Maybe the answer is for Stephen. Stephen's heard all of our comments. Maybe he can think on it and send us an email in a day or two that says, okay, based on our timeline of when we typically contact people and when we typically print and whatever he recommends. I don't want to make it extra. I don't want to make an extra burden, especially if applicants continue to be, totally random in how they respond.
Yeah.
We're just trying to solve a problem, but that may not have a solution.
I still see Portia in the list. She may come back. Hopefully you're still there, Portia.
There she is. Oh, you're muted.
So I guess what I was going to say also is that Paul and Judy, that we have a long-term issue of what we should do, when our schedule resumes to be monthly or whatever. And then we have this other problem of what about the people where the packet goes out tomorrow? Mm-hmm. And what do we do about the people whose packet comes in September? And I think maybe different communications from the chair would go to different of those groups. For the ones who are on tomorrow's packet, I don't think we can do an individualized evaluation. Right, it just has to be a stern warning saying, we've had to defer a lot of stuff, even though we were waiting 6 months, don't be one of them as a general matter. Mm-hmm. And then maybe for September, we could do it. We could tell them at a week from now, a similar message, but more targeted with them having more time to actually get it in time for the packet. And then what we do in November and December when we're back in a normal pattern, that can be something Stephen can advise us about the ideal timing.
Okay.
Ms. Clark, I wanted to let you know that we didn't have the benefit of hearing your comments. When you came back in, you were unfortunately muted. I believe you still are.
I am. I'm sorry. I was playing with buttons because I'm not able to see any of the pictures, but.
We can hear you now.
Okay. I'm unmuted.
You can't see us, Portia?
No, I cannot.
You have to work on that because that must be lonely.
I see all the initials and I can hear you, but I'm only seeing myself.
Huh.
You can see you, Miss Clark.
Okay.
Yeah, but it is a little lonely when you can't see anybody. You're just talking into the air.
Well, that's part of this virtual environment.
All right. So are we saying that there's an opportunity for a letter from me to go out for this next batch? Or is that
not for next week? If they're going to be printed tomorrow, they're not.
They're going to be printed a week.
No.
Oh, tomorrow. Oh, tomorrow. Yeah,
because
you're right.
We're getting a packet on Friday for next week.
Oh, that tomorrow.
No, that one clearly won't work. Something for September? Yeah, sure.
All right. So your understanding is we're going to have the same problem next week that we had this week, but in the future, we hope to avoid it. Okay.
Yeah, and again, I mean, if we get, a few, it's just that we got inundated. It was like a 36-page attachment.
That's crazy.
That scared us.
And I couldn't read it on my phone, so I had to get to a laptop to even look at it. Anyway, guess what? I'm going to move adjournment. How about that?
How about this? I don't think you have to move. I'll just declare that our agenda having been completed, we are adjourned.
Yippee skippy.